y'all can just relax until we get a minority member here, so you can talk, visit. Committee will now come to order. Whoa. Most people know how we'll conduct this day's hearing. We have 4 panels. We actually have 2 subject matters. The first panel will go relatively quick. Will be Congressman Billy Long. Then the second panel will be the EPA, and then we'll follow by panel 3 and panel 4. So probably a productive couple hours this morning. So with that, we'd like to welcome you all, and I recognize myself for 5 minutes for my opening statement. The subcommittee set an official record last week for length of a 2-panel hearing, which was very short. But today we make up for it with 4 panels. The chair appreciates members' judicious use of their time last week and hopes that we can have a repeat performance. On behalf of the whole subcommittee, we extend congratulations to a lucky guy, Jonathan Elkin, and our very best wishes to him and his new bride, Minority Counsel Jacqueline Cohen, who were recently married. Throughout this Congress, our committee has been investigating places where Congress can enhance opportunities for growing the private sector of our economy, as well as examining places where duplicative red tape creates more burdens, but not greater protection. Our hearing today will examine legislative measures that touch upon each of these concepts. The first bill is a discussion draft which directs EPA to collect better information on recyclable materials. As co-chairman of the House Recycling Caucus, I think the aspect we are looking into is particularly interesting, and I think we should better understand the need for this legislation. For decades, the Environmental Protection Agency has been publishing a biannual report showing what products and materials are commonly collected and disposed. All of these materials, including paper, glass, and aluminum, are generated by residential and commercial sectors and are recycled, reused, combusted, or landfilled. Despite all that has been accomplished in the collection of recyclables, there is concern among several recyclers that a considerable amount of quality feedstock materials are not ultimately being processed and reused. Many recyclers believe by asking smarter questions and collecting better data, it will lend us to solutions to this problem. The discussion draft directs the EPA with the Energy and Commerce Departments to gather and review voluntarily submitted information on waste streams and recycling from government and private entities. Specifically, the discussion draft requires EPA to report to Congress within 2 years on each type of recycled material separately and cover the quantities collected, the method of collection, the amount of recoverable material, and the amount disposed. Importantly, the discussion draft leaves it to the private sector to figure out how best to use this information and does not create federal recycling regulations. The second bill under consideration today is H.R. 2997, the Superfund Common Sense Act. The bill arises from the concern that courts or EPA will spell out something in law that is unwarranted or redundant and never directed by Congress. Currently, Section 103 of the Comprehensive Environmental Response, Compensation, and Liability Act, commonly known as CERCLA, and Section 304 of the Emergency Planning and Community Right to Know Act, commonly known as EPCRA, establish reporting requirements for the release of hazardous substances that are above reportable quantities. Superfund also imposes strict joint, several, and retroactive liability for the release of hazardous substances and has response and abatement provisions. While manure has not been classified as a hazardous waste, concern exists based on past legal challenges that litigation or future regulation could change that equation. Of note, in 2008, EPA issued a final rule exempting all reporting requirements for air releases from manure at farms under Section 103 of CERCLA. The final rule also exempted certain livestock farms based upon size that had air emissions from animal waste that met or exceeded the level for reporting under EPCRA Section 304. However, on October 21, 2011, EPA stated in the Federal Register that was on a separate track to develop regulations to amend reporting requirements for livestock operations for air emissions under CERCLA and EPCRA. H.R. 2997 clarifies manure is not included in the meaning of hazardous substance or a pollutant of contaminant under CERCLA. H.R. 2997 also eliminates the emissions reporting requirement for releases associated with manure under CERCLA Section 103 and Section 304 of EPCRA. In addition, by changing the definition of hazardous substance, pollutant, or contaminant under CERCLA, H.R. 2997 also removes liability for releases of manure and precludes use of CERCLA sections dealing with response authorities and abatement actions. While H.R. 2997 makes explicit the application of CERCLA and EPCRA as it relates to releases associated with manure, the bill preserves the applicability of other federal, state, and local environmental law as it relates to the definition of manure or the responsibilities or liabilities of persons regarding the treatment, storage, or disposal of manure. I want to thank all of our witnesses for coming here to lend their time and experience to us. I look forward to their testimony. My time has expired, and now I'd like to recognize the ranking member of the subcommittee, Mr. Green from Texas, for 5 minutes.
Mr. Chairman, I want to thank you for holding this hearing today, and I'd like to welcome our witnesses, and particularly our fellow member from Missouri, Congressman Long. Thank you for coming. Today we're here to discuss two different bills, a discussion draft entitled Increasing Manufacturing Competitiveness Through Improved Recycling Act of 2012, offered by our colleague on our committee, Mr. Sullivan from Oklahoma, and H.R. 2997, the Superfund Common Sense Act, offered by Congressman Long from Missouri. While I appreciate your willingness to testify today, I have some concerns about your bill, which would exempt manure from cleanup, injunction, and reporting authorities available under the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, also referred to Superfund, the Emergency Planning and Community Right to Know Act of 1986. The Superfund Act, as amended by amendments over the years, authorizes federal cleanup of releases of hazardous substances, imposes liability for cleanup, and provides for restoration or replacement of natural resources affected by the release. I have two Superfund sites in our district, and so I can appreciate the necessity of the program. While I share and appreciate your concern that small farms not be required to file reports on animal waste, I think we need to recognize that exempting concentrated animal feeding operations, also known as CAFOs, is highly controversial and could have serious ramifications for communities across our country should contamination occur at a large agribusiness facility. CAFOs store very large amounts of animal waste in concentrated facilities, which does not occur naturally at or are at most farms. That's why the EPA currently differentiates between the two, and the small farms are exempted. Studies have shown that these CAFOs emit large amounts of hazardous ammonia and hydrogen sulfide, which have been linked to health concerns, including chronic respiratory, neurological, and other problems. That's why the law requires reporting, because emergency response removal and hazardous release controls depend on the accurate information in order to protect public health and the environment. H.R. 2997 would eliminate both the notification and reporting requirements for all releases associated with manure, including ammonia and hydrogen sulfide air releases. reporting aside, the bill also prevents EPA from using CLERCLA to clean up hazardous substance releases from manure or issuing an order to a facility to clean up releases of hazardous substances resulting from manure components, meaning that the bill would exempt large agribusiness from federal liability of any natural resource damages that may result from a damaging spill. I mentioned before I have concerns about small farms, and I know our committee is interested in recycling on our second bill. Obviously, a lot of that can be recycled and very beneficial use. But my concern is H.R. 2997 with the cost of cleanup damage by the hazardous substance. It's responsibility of the ratepayers of local communities. The second bill we'll look at today is the Increasing Manufacturing Competitiveness and Recycling Act. I agree it's important for us to understand where the recyclables collected through recycling programs end up. Better information leads to more efficient recycling that maximizes environmental gain and material efficiency and makes sense for our businesses. However, I'm concerned that by making a survey voluntary, the participation would not lead to a type of data that we're aiming for. Also struggling to understand why states or trade associations cannot do the same type of voluntary survey. Given our budget issues, I think we should ensure that data could not be obtained through existing reporting regimens. With that, I look forward to testimony of our witnesses, Mr. Chairman, and thank you for calling the hearing.
I thank my friend, and I'd like to recognize the chairman of the full committee, Mr. Upton, for 5 minutes.
Well, thank you, Mr. Chairman. Today we're going to hear testimony on two bills. Mr. Sullivan's discussion draft on recycling, Mr. Long's bill clarifying that manure is not defined as a hazardous substance under CERCLA. Monday, I visited a paper recycling plant in Michigan, employing hundreds of folks who make 100% recycled paperboard. In my view, these private sector innovators are the real green jobs that we need to be promoting. Folks at this facility in Kalamazoo are concerned about getting access to high-quality paper fibers that they can recycle into new paper products, whether it be cartons, cereal boxes, or other types of packaging. They're frustrated that more than 40% of good paper fiber goes overseas or into a landfill. They're not asking for federal laws mandating recycling, but they do feel that better information is needed both to help the American public understand recycling and to help the recycling community gain access to the types and quantities of feedstock that needs to be competitive. The second bill that we're going to consider is H.R. 2997, the Superfund Common Sense Act by Mr. Long. This legislation will remove a lot of anxiety and bureaucratic compliance costs for folks who operate animal feeding operations. The bill would do two things. First, it clarifies that manure is not included in CERCLA as a hazardous substance or a pollutant or contaminant. This alleviates farmer and rancher worries over possible CERCLA exposure from manure, but it preserves claims under a host of other environmental laws, from the Clean Water Act and Clean Air Act to various state and local ordinances. Second, the bill eliminates some red tape paperwork reporting concerns too. So, Mr. Chairman, we all expect animal feeding operations to operate responsibly and with respect for their neighbors and the law. But today we ask, is it more important to apply lots of laws to one operation or just the right ones? So to our witnesses, I say thanks for coming. I yield back to other members that would like to speak. Mr. Harper, Mr. Gardner. Mr. Gardner.
Thank you, Chairman Upton, for the opportunity for yielding time, and thank you, Chairman Shimkus and Ranking Member Green as well for convening this hearing on two very important pieces of legislation which will help our agricultural community improve energy efficiency and increase international competitiveness. The first bill that we've talked about, Increasing Manufacturing Competitiveness through Improved Recycling Act, directs the EPA and stakeholders to take steps to improve data collection related to the recovery of recyclable material, review ways to increase the collection of recyclable materials. In a EPA Franklin Associates report, we've found out that the state of Colorado generates approximately 157,000 tons of glass, and only 32,000 tons, or 21%, is recycled, making a big difference. One of my constituents, an employer that has over 200 men and women working at the facility, Owens, Illinois, is very interested in the issues of recycling. And as I toured their facility, learning about what it takes to make their glass product, the important role that recycling has within that industry. And that's why I think this legislation could be helpful. The second bill we are considering today will provide needed certainty to our agricultural community and help protect the livelihood of farmers and ranchers throughout the United States. My district is the 11th largest agricultural producing district in Congress. Many of our producers use concentrated animal feeding operations, or CAFOs, and CERCLA and the Emergency Planning and Community Right to Know Act could soon be used to subject manure to redundant requirements or stringent regulations. This H.R. 2997 would exclude animal manure from the definition of hazardous substance. In a letter that we received from the Colorado Livestock Association, they believe that H.R. 2997, and I quote, will reduce unproductive expenditures by individuals engaged in producing the nation's supplies of protein and milk products without in any way compromising the health and safety of the public. The CAFOs are used throughout Colorado, and this legislation is essential to protecting our producers from undue regulations that could significantly hurt their business. Thank you to our colleague from Missouri, and certainly thank you, Chairman, and I yield back my time.
Time has been yielded back. Chair now recognizes Ranking Member of the Full Committee, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. Today we'll hear testimony on a bill called the Superfund Common Sense Act. Well, my Republican colleagues will talk about a small family farmer with a single cow grazing out in the pasture. They will warn of EPA rushing through the farm gate, calling a cow patty hazardous, and placing costly and burdensome requirements on an innocent, freckle-faced farm boy. And they will use this imagery to argue that farmers need to be protected from Superfund and the EPA. We've all heard of what's called a Trojan horse. I call this a Trojan cow. There's one big problem with the Republican narrative. It's completely made up. In reality, this legislation is about exempting giant agribusiness from liability if they pollute the land and groundwater. Time after time, this committee has put interests of big corporations and their billionaire owners over the interests of struggling middle class. Many farming operations comply with the law, but there are times when some do not. And when that happens, liability under Superfund is essential. That's common sense. An example is what happened in Waco, Texas, where poultry factory farms contaminated the sole source of drinking water. The city successfully made a claim under Superfund for reimbursement for the cost of cleaning up the phosphorus pollution. Without Superfund, the local taxpayers would have been defenseless. Another example occurred in Tulsa, Oklahoma, which recovered funds from Tyson Foods under Superfund when poultry operations there contaminated the city's water. That's why I am so worried about this piece of legislation, despite its very nice name, because it's being promoted under false pretenses. We've already voted over 250 times on the House floor to roll back environmental protections. And if this bill makes it to the floor, it will only add to this total. We've considered a bill that would have blocked President Obama's historic tailpipe standards that will save consumers thousands of dollars and dramatically reduce our dependence on foreign oil. The false pretense for that bill was that money-saving fuel efficiency standards are an energy tax. We passed a bill to allow mining operations like the one in Libby, Montana, to spew cancer-causing particles into neighboring communities. Well, the rationale for that bill was that we needed to prevent EPA from regulating farm dust, even though EPA told us they have no intention of regulating farm dust. Last week, the House passed legislation that included the latter amendment, which would cut the heart out of the Clean Air Act by gutting the Act's health-based standards. The completely unrelated argument for that bill was that we needed to study rules that might be proposed on refineries. Well, House Republicans have voted to nullify rules to cut mercury pollution from waste incinerators, industrial boilers, and cement kilns. The argument was that we just needed to give EPA more time to get the rules right. Mr. Chairman, I've said this before and I repeat it again. This is the most anti-environmental House of Representatives in the history of the country. And today's bill is one more effort to make the country safe for pollution. and I strongly oppose the bill. Before I yield back, however, I'd like to note that we're also examining legislation relating to recycling today. While this bill appears likely to accomplish very little, I look forward to hearing a testimony about it. Common sense, Superfund, common sense. Well, we're all for Superfund and common sense, but it's not common sense to put shackles on Superfund and let polluters cause serious consequences to the taxpayers and the middle class people living in the communities nearby. Yield back my time.
The gentleman yields back his time. Now the chair recognizes our own freckled-faced farm boy from the state of Missouri. Mr. Long, you're recognized for 5 minutes.
Thank you. First off, I'd like to thank you, Chairman Shimkus and Ranking Member Green, and all the subcommittee members for allowing me to testify this morning. Last year, I introduced a bill which would exempt livestock operations from the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA regulation. The bill, H.R. 2997, or the Superfund Common Sense Act, would also exempt livestock operations from Emergency Planning and Community Right to Know Act, the EPCRA, reporting requirements. Livestock producers, along with other small businesses, face increasing regulatory uncertainty, much of it stemming from potential or proposed environmental agency rules. The nation's livestock producers, or agricultural industry as a whole, cannot afford to comply with unnecessary regulations. The CERCLA law, which we know created the Superfund, was enacted in Congress in 1980 because of the Love Canal incident. The law was never meant to regulate livestock manure, but its activists may use ambiguities in the law to create new livestock operation regulations. I think it was I can't say it again, so I'll give up on it. My bill clarifies that the reporting requirements under CERCLA and EPCRA will not apply to animal manure or its emissions. It does not make sense to lump tens of thousands of farms and livestock producers under the same severe liability provisions that apply to nearly 1,300 federal Superfund toxic waste sites. My bill will provide more certainty for producers and more common sense to these laws. If the EPA does not choose to exempt cattle operations from release reporting obligations, the operations may be required to file daily reports with the federal, state, and local emergency responders. Additionally, measuring ammonia from open-air beef feedlots is impractical since there is no pipe or any other way to measure ammonia emissions directly. Because ammonia is dispersed in the air before measurement, the wind speed and direction, air pressure, and temperature all affect emissions. Measuring the emission depends on capturing the whole cloud or air sample at a specific time and space. This would require all kinds of instruments, upwind, downwind from the source, much like a complete set of meteorological instruments measuring wind speed, direction, pressure, and the like. Since these instruments could only measure concentrations at relatively few points in the airspace of varying size and shape over short periods of time, large errors are likely and data would be unreliable. These are supposed to be livestock operations, not small weather stations. Annual continuous release reports may be a continued option for large operations, but because emissions from open-air beef cattle operations also vary depending on the climate, the feed, the weather, the age of the cattle, and many other variables, there is no guarantee the reports would be useful since the emissions are obviously not continuous or stable. A continuous release, by the law's definition, a release that requires without interruption or abatement, or that is routine, anticipated, and intermittent, and incidental to normal operations or treatment processes. The release must also be stable in quality and rate, which means that it is predictable and regular in the amount and rate of emissions. Finally, neither ammonia nor hydrogen sulfide is regulated as a regulated hazardous air pollutant under the Clean Air Act. I introduced my bill in September of 2011. When the EPA was asked for comment, an EPA spokesman stated the following on October the 20th, 2011, in the Energy and Environmental Daily article, and I quote, "This one joins the growing list of myths being perpetrated about the EPA rules." And then she added, "It's unfortunate that time is being spent on solving a perceived problem that does not exist. I will note for the record there was no mention of a freckle-faced farm boy, but the intent was there. The next day's Federal Register, after they denied it, the next day's Federal Register was printed. The EPA is currently in the process of developing a rulemaking to amend reporting requirements for livestock operations on air emissions under CERCLA Section 103 and EPCRA Section 304. Also on November 8, 2011, Congressional Research Service report stated that the EPA anticipates it will propose a new or revised rule regulating livestock waste in 2012. Mr. Chairman, I would also like to mention that the United States Department of Agriculture has gotten so out of control with regulations. I have had constituents of mine threatened with large fines and confiscation of property because their small rabbit breeding operation was considered illegal. This kind of regulatory overreach does not reflect self-governance, and to come to think of it, there was a small freckle-faced boy involved in that case. This kind of regulatory overreach does not reflect self-governance, which is a fundamental principle of our nation. Where does the individual citizen go to vote out or an abusive regulator or overbearing bureaucrat? Where is that ballot box? It is time for us, the United States Congress, to reclaim much of the authority we have surrendered to the executive branch bureaucracy. The federal government's job is not to stifle economic growth and intimidate the American people. The constituents I mentioned earlier only wanted to breed rabbits and be left alone in peace, but they instead were punished by an expensive and time-consuming process brought on by ridiculous regulations. I would mention that they had ceased raising rabbits for a few years before they brought this charge, which was also ridiculous. I would also like to point out what happened in Illinois last August. At a town hall meeting where President Obama held in Atkinson, Illinois, a local corn and soybean farmer asked the President about more possible EPA regulations covering dust, noise, and water runoff. The President said, and I quote, "The folks in Washington like to get all ginned up about things that aren't necessarily happening." Then he instructed the gentleman to contact the USDA. Well, one reporter followed this direction and called the USDA. After several phone calls and referrals to various agencies, including the Illinois Department of Agriculture and the Illinois Farm Bureau, an answer was not found. I again want to thank you, Chairman Shimkus and Ranking Member Green, along with members of the subcommittee, for allowing me to testify today. I look forward to working with you on this common sense solution.
We thank you for joining us, and it's our tradition not to take questions, so thanks, and we'll now. Billy. Yeah. Without objection, the ranking member of the full committee will be recognized for how much time you want, Ms.
Let's try 5 minutes, and I'll try not to go that long.
Okay, for 5 minutes.
I thank you.
Without objections to order.
I thank you for your explanation of the bill and willingness to answer my questions. Your statement says that the bill clarifies that the reporting requirements under Superfund and EPCRA will not apply to animal manure or its emissions. That's what you're trying to accomplish. Is this the sole intent of the bill, to exempt manure and its emissions from the reporting requirements under Superfund and EPCRA?
The intent of the bill is to stop trying to use something that was created for Time Beach in Missouri or Love Canal, an actual toxic waste Superfund Cleanup Act for manure.
Okay.
That's the intent of the bill.
Now, EPA is going to testify that the impact will go far beyond the reporting requirement, and it blocks authority to clean up contaminated sites, prevent further contamination through injunction, recover compensation from responsible parties for cleanup activities. Now, this would severely undermine the principle of the polluter should pay to clean up their pollution. Instead, the cost of cleanup would be shifted to the taxpayers. Is it your intent in this legislation to shield polluters from liability and shift the cost of cleanup to taxpayers?
Absolutely not, but I want the EPA to use the rules that are on their books now for such ventures. I do not want them to get off into this la-la land of trying to use a Superfund that was for Times Beach and Love Canal for cow manure.
Okay. And then one last question. Would you support redrafting the language in your bill to ensure that the polluter pays principle is upheld and that the cleanup costs are not shifted to innocent taxpayers?
I'll have to get back to you on that, which I will do.
But you want to accomplish that goal?
I will get back to you on, yes.
Okay. Thank you very much. I appreciate your answers.
Thank you, my colleague. And just for Billy, if you just wait, I'll recognize myself for a minute and a half without objection. Things we want to continue to highlight is the Clean Water Act, Section 311F, authorizes recovery of costs incurred pursuant to hazardous substance mitigation. Requirements under Section 311C of the Clean Water Act, period. Section 3007 of the Solid Waste Disposal Act authorizes EPA to obtain information or inspect facilities where hazardous waste have been generated, stored, disposed, and are transported. And then Section 7002 of the Solid Waste Disposal Act authorizes citizen suits against any person or the federal government to enforce solid or hazardous waste laws. Section 7003 of the Solid Waste Disposal Act gives EPA authority to address imminent hazards. So the point being, and I think part of my colleagues' coming forward is a set of regulations that you can follow, not piling on, and that's kind of, and that's what there's a legislative hearing. I appreciate my colleague from California raising the question, and thank my colleague from Missouri for joining us. And with that, I'll dismiss this and panel the second panel.
Mr. Chairman, I just want you to know for public information, I told our colleague that I wouldn't ask him any questions about the bill.
And now I'd like to welcome the Honorable Matthew Stanislaus, Assistant Administrator, Office of Solid Waste and Emergency Response with the United States Environmental Protection Agency. He's been here before. Thank you for coming back. Sir, your full statement is in the record, and you're recognized for 5 minutes.
Mr. Chairman, Ranking Member Green, and members of the subcommittee, I am Matty Stanislaus, Assistant Administrator for EPA's Office of Solid Waste and Emergency Response. Thank you for the opportunity to testify today on H.R. 2997, which would amend the Comprehensive Environmental Response Compensation Liability Act, otherwise known as CERCLA, and on a legislative proposal regarding recycling data collection and a report to Congress, the Increasing Manufacturing Competitiveness through Improved Recycling Act of 2012. Regarding H.R. 2997 and the issue of air emissions from animal waste, EPA in December 2008 issued a final rule referred to as CERCLA-EPCRA Administrative Reporting Exemption for air releases of hazardous substances from animal waste at farms. The exemption became effective on January 20, 2009 and exempt farms from reporting under CERCLA Section 103. The final rule also exempts farms that release hazardous substances from animal waste to the air from reporting under EPCRA Section 304 if they are stable or confine fewer than the number of animals to be considered a large concentrated animal feeding operation thresholds as defined in the Clean Water Act regulations. Let me be clear, EPA has never designated manure as a hazardous substance, nor has the EPA ever designated a farm a Superfund site, and has no plans to do so. We believe EPA's 2008 final rule has addressed concerns raised by the farm sector related to air releases reporting under CERCLA and EPCRA without removing important CERCLA response authorities. While we do not consider manure a hazardous substance, there are substances associated with manure, such as ammonia and hydrogen sulfide, that are by definition hazardous substances and can threaten public health and the environment. The effect of H.R. 2997 will be to prevent the EPA from using CERCLA response authorities to respond to releases to the environment when the manure is the source of those hazardous substances, even if the release, for instance, such as the failure of a large manure waste lagoon, presents a substantial danger to the public health and the environment. It would also prevent the agency from issuing a CERCLA abatement orders to require immediate response to damaging releases that could threaten drinking water sources as well as residents. Therefore, we have concerns with the broad impacts of this bill. Now turning to the increasing manufacturing competitiveness through the Improved Recycling Act and recycling data collection, EPA recognized that there are limited aggregate data to evaluate the success of recycling programs at local, state, regional, or national level. EPA's Municipal Solid Waste Characterization Report was designed to provide a snapshot of U.S. Municipal solid waste stream and is a primary data source at the national level. The report includes data and trends since 1960 and analyzed the composition and amounts of municipal solid waste in the U.S. and how those materials are recycled, incinerated, and landfilled. It is used by a broad range of entities, including local, state, federal governments, NGOs, the public, academia, and industry for a variety of progressively more complex and specific purposes, some of which were not originally anticipated or designed by the original report. Recognizing that revisions of the MSW characterization report could be helpful, EPA issued a Federal Register notice in September 2011 and received public comments from industry, local and state governments, and recycling groups. EPA plans to revise and expand the next characterization report to reflect an ongoing shift to sustainable materials management, essentially to identify opportunities to maximize the economic and environmental benefit from reusing materials rather than throwing them away. We believe that the data collected for the MSW characterization report will inform the public and private sector on current recycling trends and practices and identify areas needed to be addressed to support increased recycling and support sustainable materials management efforts. EPA is evaluating new methodologies and will continue to publish the report annually with incremental changes over time. Moreover, we continue to engage industry to identify ways to enable greater reuse and recycling of materials because of the economic benefits, including job creation, as well as its environmental benefits. While we support the goals of the draft bill, we have several comments. The bill does not provide authority to require various sources referenced in the draft bill to provide specified information to achieve its goal. While the draft legislation intends for the information collected to be voluntary, it may fall short of its goal to provide the enhanced data needed to help more informed decision-making among policymakers and government officials and help the private sector increase the use of recyclable materials. EPA's planned revision and expansion of its MSW characterization report will help inform the public and private sector about sustainable materials management. While the draft bill states that the information collected by EPA is intended to be voluntary, this appears to be contradicted by the confidential business information provision. Current law already provides those protections, and should an owner have such a confidential proprietary information, they could seek those protections. Having the broad protections defined in the rule kind of gets in the way of the intention of the bill. With that, Mr. Chairman, I close my remarks.
Thank you very much. I recognize myself for 5 minutes for the opening round of questions. I want to follow up on what Mr. Long started about really addressing a timeline, because I think that's kind of raised a lot of issues too. So on October 21st of 2008, EPA proposed in the Federal Register the National Pollutant Discharge Elimination System Concentrated Animal Feeding Operation Reporting Rule. In it, EPA stated that it is, quote unquote, on a separate track to develop a rulemaking to amend reporting requirements for livestock operations on air emissions under CERCLA, Section 103, and EPCRA, Section 304. Can you tell me the status of the separate rulemaking is for the reporting of EPCRA Section 304 and CERCLA Section 103?
Sure. Currently, we're in the midst of collecting air emissions data, working with industry on that modeling. There's actually a separate office outside of my office is collecting that data. So we're in the midst of evaluating that data. But we cannot move forward on rulemaking until that data collection is done. So I don't have a precise date, but I can follow up with information regarding that.
And if you would, we'd appreciate that. And what was the impetus for changing the rule issued by EPA in 2008 on these matters? What caused the change from the position taken in 2008 to the position of 21 October 2011?
Well, I mean, we heard from various stakeholders as to the underlying basis of that determination of where we drew the line in terms of the size of facilities that would be exempted and those that will still be covered by the rule. So we are taking a hard look as to the data support for that determination.
Were you petitioned?
I'm not sure. Yeah, I think we were in litigation, and we remanded from that litigation to evaluate the rule. So we were sued. There was not, so we decided to remand to EPA to examine another rule.
Which brings up my favorite subject, which is the judgment fund and compensation for suits and who pays what, but that's for another hearing. What is the status of the proposed rule of October 20? Well, we've kind of answered that. Will that proposed rule have any impact on the way these agricultural operations are governed under CERCLA or EPCRA?
Well, we're taking a look at just the public notification provision and looking at the air emission studies to inform that. It's strictly with respect to the notification of emissions from these facilities, and not other aspects of CERCLA.
EPA has testified that it has never filed a CERCLA Section 104 action, nor anything under CERCLA Section 106 or 107 with regard to animal farming operations. How many total RCRA Section 703 imminent hazard action cases has EPA brought against a farming operation?
I don't have that information. I will get that to you.
Thank you. Is it fair to say the EPA considers laws other than CERCLA emergency authority as appropriate response to environmental threats which may occur at animal agriculture facilities?
Clearly, we have used other authorities in certain circumstances. As I testified, what this would do, it would prevent the use of what we call abatement orders. So the immediate moving forward to clean up the result of a major spill and to prevent immediate impacts like drinking water impacts and impacts to local residents.
If EPA changed the 2008 reporting regulation to include more animal facilities in CERCLA Section 103 and EPCRA Section 304, how many new facilities are subject to EPCRA reporting?
We don't have that analysis yet. We've not made a decision to change.
Do you have a projection of the cost that it would incur of the additional reporting?
Yeah, I mean, clearly, if we decide to change, we'll conduct that analysis.
And will you conduct an analysis of the additional cost to the agency of receiving those reports?
Sure.
About the cost of receiving and acting on those reports?
Acting depending on yes, under our authorities, yes.
Okay, and I'll end here, and I thank you for your time. The point being, we think that under current law, as I've stated earlier, that the duplication of this is just redundant, costly, inefficient, and that's why we raised this issue. So thank you for your time, and I yield back my time and recognize the ranking member of the subcommittee, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Administrator, again, thank you for being here. Supporters of H.R. 2997 say that the Clean Water Act, Clean Air Act, and the Resource Conservation Recovery Act sufficiently regulate and address any environmental damage that would result from manure contamination. Why do you feel that CERCLA is necessary, still necessary?
Well, yeah, CERCLA serves a distinct purpose. So there are two aspects that we're talking about here today. One is to preserve the ability to respond to a major catastrophic event that requires an immediate cleanup, so there are no public health or environmental harms. We want to preserve that, and it's critical that we preserve that authority. The other is for large facilities, particularly local responders and local government. I pointed out during the original rulemaking the real important need for that information so they can effectively prepare should an event occur.
When there are concerns about small farms being captured by future regulations. What are you talking about? I know there's a difference between my family farm and a feedlot, yeah, for example, although there could be a family farm that includes a feedlot. So what are the distinctions?
Well, yeah, it is defined under the Clean Water Act. Currently, only large CAFOs are subject to the rule with a significant large number of species. I can give you the various, so I could provide afterwards.
Yeah, if you just submit it to us. And granted, there's some concern, obviously, that if you're downwind or downstream or down a hill from a large, large feedlot, that there's an issue. But again, a small farm typically is not the issue. So I think that's
That is correct.
some witnesses today argue that phosphates in manure are not now, nor they have ever been equivalent to harmful chemicals that CERCLA has been addressing in the last 32 years. Do you agree with that?
I'm sorry, could you say that one more time?
That phosphates in manure that are not now, nor have they ever been equivalent to harmful chemicals that CERCLA has been addressing for the last 32 years. Do you think phosphates are those a type of harmful chemical in certain numbers?
Yeah, I mean, really, those chemicals and other chemicals listed as a hazardous substance, they're listed for a reason because there are underlying studies that show a risk and impact if it's above a certain level of concentration.
Okay. The Congressman Long in his statement talked about measuring ammonia from open air beef cattle feedlots is impractical since there's no pipe or any other way to measure ammonia emissions. I have in our district lots of industrial capacity, and most of my plants now do fence line monitoring. Could we see the same type of fence line monitoring if you had a huge feedlot operation for testing for ammonia like we test for other releases?
We don't currently envision that. We're not currently, I mean, that's not part of the rule that we're talking about.
But that's what happens. Like I said, I have refineries and chemical plants who have in the last 10 years have adopted that simply because they want to know what they're going to be blamed for instead of their neighbors, since they're literally fence line to fence line.
Yeah.
But that's a way that you can measure ammonia from a facility.
Well, yeah, you could do fence, but we're not proposing that at the moment.
On the recycling bill, I share your concerns about the surveys being voluntary. Can you elaborate on why these concerns, and if we make them mandatory, are these specific authorities that would need to be included in the legislation for you to carry out your study?
Well, very simply, I think the good intent of the bill is to provide more granular data from a variety of sources. So some of those sources are state and local government, some are industry, and some of the industry is industry to industry. So to really provide the kind of information and granularity that industry wants and other sectors want, we would need to have a comprehensive set of data. So if we have data gaps, that really cuts against the intended nature of really advancing the environmental, economic protections of that. So without that, I don't see how the goals would be met.
Well, and you could end up with just self-selection and really holes in your data that you couldn't really address effectively.
That's right. I mean, some industries, some companies voluntarily put that information up, and others would not. We would not be able to make a industry-specific judgment that is statistically significant in some cases if we have data gaps.
Okay. Mr. Bragg, in our fourth panel today, the 2012 Interior Environment Appropriations Act, Congress directed EPA to report to Congress on development of process to collect additional data on recovery rates achieved by U.S. recycling programs. That report was due in March of this year. Do you know the status of that report?
Yeah, that was submitted on that date. Yeah, that was submitted, yeah.
Okay, thank you. Mr. Chairman, I don't have any other questions.
Gentleman's time's expired. Chair recognizes the Vice Chairman of the committee, Mr. Murphy, for 5 minutes.
Thank you. Welcome here. I understand EPA identified better collection of data on recycling as an issue in your fiscal year 2012 justification on appropriations. In addition, I understand that in the fiscal year 2012 appropriations bill, Congress directed the EPA to develop a plan to collect better information and report on that to Congress. Finally, I understand that EPA has solicited public comment on what information you should include in your municipal solid waste characterization report. So, first of all, if you and Congress agree this is important, when can we expect the report to Congress on improving recycling data? When can we expect that?
Yeah, so the report has already been submitted per the congressional direction. We are advancing more granular data versus the characterization study. We did a Federal Register notice. We solicited comments from a variety of stakeholders, and we're actually expanding the data collection under that report.
So if the gentleman would yield, what I think you've given an initial response, but there's going to be a fuller analysis. Is that what you're testifying?
Well,
you're talking about granular.
Yeah, so I just want to make sure I understand the question. So
I'd like to know what granular means. Is it the full report?
So we submitted a report per congressional direction this year. As identified in that report, we identified the need to have better data, particularly data that goes beyond historic recycling, really looks at what we call material management opportunities and where can we look at opportunities to reuse and re-engineer. So we solicited comments via a Federal Register notice. We're in the midst of evaluating that, and our intention is, with respect to the data collection and the report that we issue publicly biannually, to have an expanded set of data.
So that full report is done or not done?
Yeah, so I think we're talking two reports. The report to Congress is done. Okay. The MSW characterization report, we issued that.
And you responded to all the public comments too?
I'm sorry, say that again?
Have you responded to all the public comment on the matter?
We're in the midst of evaluating that before
okay.
that, yeah.
Can you detail the steps that EPA has taken to improve your existing municipal solid waste characterization report? Can you detail for us, can you give information on the steps the EPA has taken to improve the existing municipal solid waste characterization?
Sure, I mean, it's contained in the report. I can follow up on that.
Does the administration consider private sector recycling part of the green economy on green jobs?
Oh, absolutely.
Yes, okay. And why hasn't EPA, through your next report, though your next report is due, why isn't EPA improving this data? I'm still confused in terms of how you're working this.
Well, that's exactly the point. Our effort currently is to actually improve the data with a real focus on identifying reuse opportunities and re-engineering opportunities. Because we've heard from lots of industries who have told us that information will be critical for them to make informed judgments.
Okay. Let me shift another thing about electronics recycling initiatives, if I could. Would you support electronic recycling initiatives that violate our trade obligations under the WTO?
I guess I'm not informed enough with respect to the international.
You can get back to us on that?
I can get back to you on that.
Does EPA have existing authority to conduct the study called for in the discussion draft on these things?
The study called for in the discussion draft, I would say we have general authority, but not, I guess not as specific as set forth in the bill.
How much funding will be expanded in the study? Do you have any idea how much funding is going to be necessary to do that?
Well, we took a look at the estimate, the amount set forth in the bill, and we believe that's inadequate. Our estimate is roughly about $800,000 a year to do that, as well as we think the timeline is too restrictive to complete the job. We think 2 years will not be enough to really do the kind of rigorous data collection that is set forth in the bill.
Thank you, Mr. Chair. I'll submit other questions for the record. Thank you.
I thank my colleague. Now Chair recognizes the Chairman Emeritus, Mr. Dingell, for 5 minutes.
Mr. Chairman, I thank you for your courtesy. Yes or no answers, if you please. If manure is consolidated into a big lagoon, does EPA consider that circumstance a naturally occurring substance in its unaltered state from a location where it is naturally found? Yes or no?
Well, I'm going to have to ask it within the answer with respect to circular authority. Circular authority would not attach to that circumstance.
Thank you. Has EPA ever responded to the release of a naturally occurring substance? Yes or no?
No.
Do you have any plans to do so?
No.
Is EPA aware that substances such as phosphorus are added to the feed at animal feeding operations? Yes or no?
I guess I'm not specifically aware, but I'm sure my staff is.
Okay. Were the Waco and Tulsa examples situations where local governments were trying to recover response costs for protection of drinking water supplies from contamination caused by dairy or other animal feeding operations? Yes or no?
I'm not specifically aware of that litigation. We were not involved in that. That's my understanding.
It was an action by local governments.
That's right.
To protect their water supplies and the public health. Is that not so?
That's what has been represented here. We were not involved in that.
And was causing substantial amounts of algae bloom, phosphorus, and other pollution of the waters of Lake Waco and the people in the area who use that for their water supply. Is that right?
Again, I'm
Yes,
not
no.
intimately familiar with the facts.
All right. Is EPA aware of any small farm operations as opposed to large-scale industrial AFOs that have triggered the reporting requirements for ammonia and hydrogen sulfide? Yes or no?
Well, the reporting requirements currently is strictly applied to large CAFOs.
All right. EPA finalized an exemption in December 2008, which exempted hazardous substance releases from animal waste from the reporting requirement. Therefore, no data has been reported since that time. Is that true?
Yeah, data under Circular 103, that is correct.
The air emission monitoring study was supposed to take 2 years, but the draft development of emissions estimating methodologies for lagoons and basins at swines and dairy animal feeding operations reported that additional analysis is needed. Is there any data that shows that the broad exemption in the bill before us is justified? Yes or no?
We're in the process of evaluating that data. We've not made a conclusion.
But you do not have the data because the study is not available to you. Is that right?
Well, there's a separate study that a separate office of EPA is conducting with data from various industrial sources.
All right. Has any public agency determined that a public health hazard existed based on the release of hydrogen sulfide at a dairy farm or other animal feeding operation? Yes or no?
I don't know whether a public health agency has made that
You know of none.
I know of none.
Now, Mr. Chairman, we are in an extraordinarily dangerous situation. On one hand, we have a reporting exemption that has prohibited collection of any data for over 3 years. On the other hand, we know that the Agency for Toxic Substances and Disease Registry has previously testified before this panel that there was a public health hazard as a result of high levels of hydrogen sulfide at a dairy farm in Minnesota. I do not believe that we need a broad exemption from reporting where we know that there is at least one significant problem. Now, if you have a big animal feed operation, i.e. one of these gigantic hog farms, or a tremendous large animal operation like you'd find at Montfort out around Longworth, Colorado. You can smell that damn thing 40 miles away. Approximately what size city would have that much manure flowing through its waste treatment system?
What size city?
Yeah.
I'm not sure I can
You've got a
even...
huge hog farm here. Got thousands of hogs. You got a huge beef lot. How many animals would be at those, and what would be the amount of the manure that would be collected there, and how would that equate to the size of a city, say Minneapolis or Cedar Rapids or Muskegon or Detroit?
Well, yeah, I can get back to you with respect to the data.
I'd like to have that. Please give us a table. Give us
Gentleman's
some
times.
appreciation of just how much manure is out there and what you do to a city if it had that kind of operation, risking both air and water pollution. Mr. Chairman, I thank you for your courtesy.
Gentleman's time has expired. The chair now recognizes, let's see who's, the gentleman, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman. EPA received $9.5 million for waste minimization and recycling in 2012, and the Obama administration requested EPA about the same amount for FY 2013. At the same time, you said that you want to focus on sustainable materials management.
Mm-hmm.
So my first question is, don't you agree that if EPA wants to be a leader on this issue, you need good information about how materials are being recycled currently?
Absolutely.
And are you telling me that you can't spend $400,000 a year for 3 years from within your current appropriations level to help get better information to solve problems you say you want to solve?
Well, we are, as I testified earlier, we are in fact have collected information and plan to include that as part of our characterization report.
If you break down that figure, it comes to about $182 per employee.
Mm-hmm.
So how do those folks even know what they should be focusing on if they don't understand how that existing recycling systems works?
Well, we have significant amount of data that we report on regularly that is used by industry, used by local government to identify economic and environmental opportunities. And we also recognize that additional and more precise data would be beneficial to advance the recycling market, and that's our intention to do so.
All right, let me ask, does the administration consider private sector recycling part of the green economy or green jobs it's trying to promote?
Well, I mean, clearly recycling by private industry is critically important. We work with industry all the time. We recognize the economic and environmental value of that. So, in fact, we have ongoing conversations with industry to advance that.
All right, my next question would be that I understand that the EPA does not have an approved information collection request under the Paperwork Reduction Act for recycling data. That means that your current report on solid waste and recycling can only rely on published information collected from, I believe, no more than 9 people. Is that correct?
I'm not sure that is correct, but I will get back to you on that in terms of the sources of data that we used for the characterization study.
Is the information asked of in the discussion draft already requested and published by EPA?
Well, if you're asking how the bill compares with the data we currently collect, we acknowledge that, one, that there's aggregate data that we're currently limited by, and clearly the ability to collect more data is important. We also I identified earlier in my testimony that if we focus on just voluntary data, it's still going to leave a gap in terms of the comprehensiveness of the data.
Right. I just want to be clear. Are you saying that you only surveyed 9 people?
No, it's not.
Or you didn't, or you don't know in this recycling?
Well, I believe that that's the 9 people relates to whether you do or do not need information collection provision. This is developed over many years, so we've gotten our sources include local and state government as well as industry. In terms of our total sources of data, I'll get back to you on that.
Well, I'm just curious if there were just a few surveys that were done, and then there was an extrapolation done based upon that information, or how that came about.
It is a yearly collection of data from multiple sources.
Okay. You say that you use a materials flow methodology to estimate the amount of recycling nationwide. Using estimates of goods produced and materials discarded or recycled and trying to do a mass balance. How can that method tell you anything about recycling systems?
Well, based on data we collect, we analyze the systems, and some of those systems are dependent on various kinds of industries. So based on the data, we extrapolate and do systems-based analysis.
Is it safe to say or fair to say that we really don't know where recycled material is coming from?
No, I wouldn't say that. I think we have a fairly good feel for recycling and various industries and opportunities for recycling in various industries. We have ongoing conversations with numerous industries that want to promote that. Clearly, more data will help advance the opportunities in recycling.
So are you able to give us a breakdown of where the recycled material comes from across
Sure,
the country?
sure. In fact, we submitted a report to Congress, and we can provide you the characterization study, any supplements to that.
Thank you, Mr. Chairman. I'll yield back.
Gentleman yields back. Chair now recognizes the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Proponents of this legislation have said that Superfund was never meant to address manure and that it is not needed to address contamination from manure. This is simply not true. The legislative history of Superfund shows that manure was considered and Superfund has been used to address contamination from manure and could be an essential tool in addressing potential future contamination. On May 19, 2000, EPA issued a notice of violation to the nation's second-largest pork producer, Premium Standard Farms, for failing to comply with release reporting obligations in Section 103 of Superfund and Section 304 of EPCRA with respect to releases of ammonia at 12 lagoons on facilities owned by Premium Standard Farms. Is that correct, Mr. Stanislaus?
I can get back to you. I don't have that specific information in front of me.
Those violations were resolved in a settlement on November 19, 2001, and a payment of a civil penalty. In September 2006, EPA also filed a civil complaint against Seaboard's Foods concentrated animal feeding operation in Oklahoma for releases of ammonia. Proponents of this bill discount the importance of these emissions. Can you explain how a community would experience an ammonia release that drifts through its neighborhood?
Well, I could generally describe it and get back to specific. I mean, clearly ammonia is listed as a hazardous substance because of underlying health studies that show a detrimental health consequence from inhaling ammonia.
Well, ammonia can cause acute and long-term health effects. What I went through were examples of federal responses to contamination from manure. States and local governments have also brought suit under Superfund based on contamination caused by manure to recover taxpayer funds spent on cleanups. The city of Tulsa, Oklahoma brought suit for contamination under Superfund, as did the city of Waco, Texas. Both of those suits settled. The state of Oklahoma, acting through the Attorney General, also brought suit under Superfund to recover cleanup costs against poultry farms in Arkansas. That case is still pending. If H.R. 2997 becomes law, will states and towns be able to use Superfund in the future to recover public funds spent cleaning up contamination from manure?
Yeah, as I testified, this would prevent the use of all of CERCLA authorities, including response and abatement orders, as well as other provisions of CERCLA.
You testified, Mr. Stanislaw, that a large manure waste lagoon could fail and present a substantial danger to public health and the environment. In such a case, if this bill were enacted, what impact would H.R. 2997 have on EPA's ability to require a response to such a spill?
One, we would not be able to issue an abatement order against a responsible party to immediately ameliorate that public health risk. Separately, if a responsible party was not willing to do so, it would prevent us from using our resources to prevent that immediate risk to public health.
As I understood the testimony from Representative Long, he said he wanted to preserve existing authorities and requirements, he argued we don't need new ones. These authorities and requirements under Superfund that we've discussed are existing authorities, aren't they?
That is correct.
And they have been since 1980, is that right?
That's right.
So turning quickly to the recycling bill, I expect that we will hear concerns from later panels that information voluntarily given to EPA about municipal waste streams will not be protected appropriately from disclosure. If a company or trade association submitted confidential business information to EPA in the context of the MSW characterization report or in any other context, what protections would the agency provide for that CBI?
We have an existing process where if a company claims confidential business information, we evaluate whether that is or not and engage the company. So there's an existing rigorous process to protect proprietary information.
Okay. Thank you very much, Mr. Chairman. I'll yield back my time.
Gentleman yields back his time. Chair recognizes gentleman from Colorado, Mr. Gardner, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Stanislaus, for being here today. In your opening statement, you stated that, as discussed above, we believe EPA's 2008 final rule, it goes on to talk about Circula EPRA, has addressed concerns raised by the farm sector. Is the farm sector supportive of this provision?
Of the bill?
You're talking about some of the things, I think in your opening statement, I wrote it down, where you talked about the EPA acting in response to concerns raised by the farm sector.
You're talking about the 2008 rule?
Right.
Yeah, I mean, I think it reflects their comments in terms of particularly ensuring that small farmers' burdens are addressed.
Okay, so the farm sector supports the 2008 rule?
Well, I think we've heard from lots of farms, and I think particularly it recognizes the small farms' issues. So the farm sector supports the rule then? Well, again, we've had multiple of stakeholders, and I'm sure that many segments of particularly the small farmers support that provision.
What's a small farm to you?
Well, small farms are those that are defined in the Clean Water Act. These are not concentrated animal feeding operations. They're below that size, and I can give you the specific details based on that.
So feedlot, they're people who don't have feedlots then, basically?
I'm sorry, say it again?
So they don't have feedlots. That's what you're describing as a small farm, as somebody without a feedlot?
Well, someone without basically an industrial level animal feeding operation.
What's an industrial level?
Well, it is defined based on the various kinds of animals used in there, and we could give you a list of what those definitions are.
Have you ever been to a confined animal feeding operation?
I've been adjacent to them, yeah.
But have you been on site? Have you been on one?
Not in it, but adjacent to it, yes.
Adjacent, what do you mean? You've driven by one?
No, I've walked in the periphery of that, fence line of that. You know?
So you've seen a feedlot, you've gone through it? Okay, very good. A couple of questions for you. In considering and requiring all CAFOs to report emissions of ammonia and hydrogen sulfide under CERCLA, you're considering that right now?
Well, we're first looking at data as well as estimating methodologies with industry and other stakeholders to make sure that we're able to estimate their emissions first. Based on that, that's going to inform our rulemaking. So we've not come to any conclusion on.
But you are considering it then?
Well, yeah, we've issued a Federal Register notice regarding
yeah,
that.
and in your October 2011 proposed Clean Water Act Section 308 rule that you were talking about using this reporting rule to gain information for livestock operation, it implies that you're considering wrapping all livestock operations under these reporting rules, and I certainly hope that that's not the path that you're planning on going down.
Yeah, I'm not familiar with that specific provision.
Do open-air cattle feedlots present an emergency situation?
Not inherently. Again, as I testified earlier, with respect to this bill, what we want to preserve is those limited circumstances where there could be a catastrophic kind of failure that results in potential public health and environmental risk.
And so what is it that responders are going to respond to at a feedlot?
So just to be clear, during the 2008 rule development, what I was articulating earlier is that from a need-to-know information, particularly of large CAFOs, emergency responders, local government officials noted that they need to know, particularly large facilities, so they can have the infrastructure in place to respond should there be a release of a significant quantity.
So I live in a small town of about 3,000 people in the eastern plains of Colorado. The Montfort feedlot, it's no longer the Montfort feedlot, but it's certainly still in existence outside of my town. It's a very large operation, employs a great number of people. Mm-hmm. So my volunteer fire department, what would the first responders there, would they be equipped with a hazmat operation to deal with this proposed emergency situation? Is that what you're trying to get at?
Generally, emergency responders need to know the kind of equipment based on what's within their jurisdiction. So it's going to be tailored around the potential releases and making sure the proper equipment.
So what would that proper equipment be for my local police department or fire department for the feedlot down the road?
Well, it's various kinds of cleanup. Cleanup equipment vary depending on the kind of releases. So I can get back to you the specific kinds.
Well, what kind of a release do you anticipate happening?
No, again, with respect to the particular issue we're talking about, we want to preserve the ability, we have a catastrophic failure that impacts, for example, drinking water sources, impacts residents, and making sure that we can immediately clean that up. So
This is like a cloud of ammonia you anticipate moving toward the town?
no. What I was specifically referring to is a major CAFO having a breach and to have significant volumes that impacts drinking water source and being able to clean that up so it doesn't compromise public health.
I see my time has expired. One last question, Mr. Chairman, if you will indulge. Are you using aerial surveillance right now to monitor CERCLA compliance with CAFOs?
Well, yeah, I think that the agency has made a statement regarding its aerial surveillance, and we can provide that to you.
So you are
Thank
using
you.
it?
Well, again, the agency has made a statement, and I'm not familiar with that. It doesn't come under my jurisdiction.
Thank you. Gentleman's time has expired. We now recognize the gentleman from North Carolina for 5 minutes, Mr. Butterfield.
Thank you, Mr. Chairman, and thank you, Administrator, for your testimony today. Continuing to improve our country's recycling programs is an important issue for many of our colleagues, and certainly is important for me. It's important for the district that I represent in eastern North Carolina. EPA currently reports the amount of materials recycled each year by collecting information made publicly available by recycling stakeholders and municipalities. The EPA has expressed interest in collecting more extensive data about recycling and has been soliciting public comments. And so I just wanted to say for the record that I look forward to working with the EPA to identify the most effective way to generate accurate and useful information to improve our recycling programs. I'm also pleased the subcommittee is discussing agriculture, very important to my district, agriculture, which accounts for nearly $70 billion annually to North Carolina's economy. I appreciate your testimony on this and other subjects as well. Let me just ask you, Administrator, let me start with this very quickly. Does EPA intend to take into consideration views of the agriculture community and the other stakeholders when revising the rule?
Oh, we're already in conversations with them. Yes. So the answer is yes.
All right. Can the EPA issue orders to require response for damaging releases of hazardous substances from manure using other statutes, such as the Clean Air Act or the Clean Water Act, the Resource Conservation and Recovery Act, or FERFRA? Are there other statutes that you can depend on?
Not to conduct an immediate cleanup.
You mentioned that manure is not a hazardous substance. We all agree on, you agree on that. Is that correct? Manure is not a hazardous substance, according to your definition.
That's right.
Is manure the only non-hazardous substance under the jurisdiction of the Superfund?
Well, again, manure is not listed as a hazardous substance, so I guess I'm not clear about your question.
Well, let me read it again. You mentioned that manure is not a hazardous substance.
That's right.
Is manure the only non-hazardous substance under the jurisdiction of CERCLA and EPRA? Or do you have other examples?
Well, again, as CERCLA is constructed, there's a list of hazardous substances, so there could be, it could be a contaminant that is not a hazardous substance that we could use our authorities to do cleanup.
Can EPA designate a farm a Superfund site in the future, prospectively?
As I testified, that is not something we have done or plan to do, again, because manure is not a listed hazardous substance.
That was in response to Mr. Dingell's question earlier, I believe.
Yeah, sure. Yeah.
Are there any barriers in place that prevent the EPA from conducting more voluntary surveys about recycling? Are there any barriers?
I don't believe there are explicit barriers. Clearly, there are procedures that we need to go through to collect information.
Have you evaluated the usefulness of voluntary surveys?
Well, yeah. In fact, we do that currently as part of our efforts.
All right. I think I'll stop right there. I yield back. Thank you. All right.
The gentleman yields back his time. Chair now recognizes the gentleman from Louisiana, Mr. Cassidy, for 5 minutes.
Hey, Mr. Stanislaw, how are you?
Good. How are you doing?
I'm good, thank you. I'm interested in the recycling, not almost as a discussion of the topic, because I'm trying to understand it. It almost seems like it is such a moving target that you may take a snapshot of what recycling activity takes place, but if somebody suddenly puts a premium on aluminum cans, it's going to dramatically increase aluminum can recycling, and if that occurs just after your snapshot, then your data is dated. And I'm saying that not to accuse or anything, just to kind of ponder. Similarly, it seems as if, I think I see in the bill that the use of recycled material to develop energy, if you will, waste burning, is not included in the bill, but if you have a cost differential that would say burn a plastic bottle for its potential energy as opposed to recycle, you're going to shunt one way versus the other. Does that make sense?
Well, clearly those decisions are made on a regular basis today.
Correct.
Yeah, and it is based on the price value of reusing it one direction or the other, and commodity prices vary. So there's a regular shift based on that.
So it almost seems, I don't want to seem nihilistic, but it almost seems more important for you to look at the variables that would influence recycling than to do a particular measure of how much we recycle.
Well, we do both, you know, so we would, and really the intention of looking at materials more holistically, as we're doing right now, is to not only look at the historic recycled waste stream, but really look at various industrial sectors, how to really maximize, sometimes closed loop, sometimes re-engineering from third parties. So looking at recycling as a fabric in the economy overall.
So I accept that. And so again, it almost seems like what the measuring at a point in time what's happening is far less important than helping a business optimize their use of recycled material to decrease marginal cost. Does that make sense?
Well, I think that partially makes sense, but in our conversations, and I'm sure you're going to hear from panelists later on, I think it's fair to say that both numerous industrial sectors as well as state and local governments in terms of really identifying the opportunities and how to put in place infrastructure and make decisions, they would welcome EPA's data to help inform those decisions.
But you seem to be agreeing with me that if you wanted to have more use of something as opposed to going to a landfill, it doesn't really matter as much to measure the amount going into the landfill as much as to measure the potential benefit from either burning it for energy combustion or for recycling it at a certain given price.
Well, I think we want to take a comprehensive look of the materials field. And so looking at what goes in a landfill is an indicator of success or failure. And so if you track it over time, you could see how effective your upstream actions have been, and have you in fact been successful in putting in place the kinds of programs so that industry can take advantage of. So there is a net reduction to landfill. So I would argue that you need to have a full life cycle of information and data.
I could almost see, though, that the price they're paying for aluminum cans would give you the same information. If there's a lot of aluminum cans, they're not paying very much, but if there's few, they're going to pay more for that which they get. That said, in your testimony, you said that you would like to have the ability to require entities to produce certain information to make your analysis more robust, I presume. Who do you imagine, I'm just asking, who would be required to produce this? And what amount of information would they be required to produce, and how onerous would be that requirement?
Yeah, you know, what I testified is where the proposed bill relies exclusively on voluntary information. I think exclusively relying on voluntary information means that it inherently means that you will have some data gaps. So I think that I would say, constrains the ability to meet the overall objective.
I'm almost out of time,
okay.
but again, I'm concerned that we're going to put some small municipality under a great burden of reporting requirements. So who would be required, and how onerous would be the requirements?
Well, I would say that where the greatest data sources and where I think both the various aspects of the recycling industry and prospective recycling industry would benefit is again, a granular level of data from industry to industry recycling opportunities. So I'll leave it all.
So not just municipal dumps, but also a manufacturing outfit that leaves scrap metal on the floor.
Well, that's where I see the greatest opportunity, is the industry to industry opportunities.
Okay, but still, how onerous would it be? You see what I'm saying? That's the key thing.
Sure, that's a fair point. Yeah.
Gentleman's time expired. I will tell you that as the chair of the recycling caucus, it's not industry who's, you don't have to worry about recycling. They're going after every dollar or cent. They leave nothing on the floor. And the importance of this debate is really the municipal side, what's being left on the table through the municipal waste stream. So, Ms. Stanislaus, thank you for your time. As per tradition, 10 days, you may get additional questions submitted for the record. If you would reply based upon members' written questions during that period of time, we'd appreciate it. Sure. Also, I'd like to get a list of programs that receive voluntarily submitted information that the EPA has. You made
on the recycling side.
On overall.
I'm sorry, say that one more time, sorry.
You stated in the question that there are programs in which you receive voluntarily information. So I'd like to know what type of programs are getting voluntary information and how you're gathering that data and what it's used for.
Okay.
And with that, seeing no other questions, you are allowed to leave, and we'll impanel this third panel. Thank you for your time.
Thank you.
We want to welcome everybody, and now we can get back to, I almost felt a little schizophrenic, bouncing back and forth between two bills. This third panel is based upon the recycling portion of the hearing, so we're happy to get back singularly focused. And with that, your full statements are submitted for the record. You'll get 5 minutes. I'm going to welcome you all first, and then we'll go to you individually for your opening statements. With us on the third panel is Mr. Charles D. Johnson, Vice President, Environment and Health and Safety of the Aluminum Association, Incorporated. Also, Ms. Lynn Bragg, President of the Glass Packaging Institute. Mr. Jonathan Gold, Senior Vice President, Recovery and Recycling Division of the Newark Group. And then Mr. John Skinner, Executive Director of the Solid Waste Association of North America. Again, we welcome you all. And we will start with Mr. Johnson for a 5-minute opening statement.
Chairman Shimkus, Ranking Member Green, and members of the committee, thank you for this opportunity to testify. My name is Charles Johnson. I'm the Vice President of Environment, Health, and Safety with the Aluminum Association. We are the trade association representing U.S. aluminum producers, recyclers, and industry suppliers. On behalf of our industry, I'd like to commend Congressman Sullivan for offering this draft bill and his continued efforts to increase recycling as a critical piece of U.S. energy and sustainability efforts. The U.S. aluminum industry believes this legislation is critical because recycling is a source of sustainable, private sector-driven green jobs. Recycling is a vital part of energy efficiency and should be part of our nation's energy solutions. And the collection of better waste and recycling data facilitated by this legislation will allow consumers, policymakers, and industry to more rapidly achieve higher recycling rates. In 2010, Americans recycled $1.6 billion in aluminum cans. If the industry's beverage can recycling goal of 75% was achieved, the payback to American consumers would be $2.1 billion. Aluminum's infinitely recyclable nature means scrap metal has high value, and the processing and recycling of the metal yields a significant impact on the economy and in job creation. Market trends are leading all recycling industries to take back more recycled material, but this material is not always available. At the same time, the American public is demanding more environmentally responsible solutions. Walmart, Target, and many others are demanding increasingly sustainable packaging with higher environmental benefits. The demands for those benefits are a part of a larger shift in consumer preferences, and this is becoming as important to our industry as access to raw materials. Our industry views the increasing manufacturing competitiveness through Improved Recycling Act of 2012 as a critical next step in advancing the practice of recycling and improving operating efficiency and environmental impact for the aluminum industry. 39% of consumers have said that they are confused about what is good or bad for the environment. Quality data allows consumers, as well as industry and policymakers, to successfully examine new proposals and plans for improving recycling using facts and not suppositions. Aluminum recycling provides a massive opportunity for energy efficiency. The metallic elemental nature of aluminum means that it is infinitely recyclable. It can be recycled over and over with no loss of quality or downcycling. In fact, 75% of all aluminum ever produced since 1888 is still in use today. Recycling aluminum saves 95% of the energy and emits only 5% of the greenhouse gases associated with primary aluminum production. In the simplest form, our business case for recycling is based on the fact that increasing recycling increases energy efficiency. The aluminum industry's position in favor of recycling is not greenwashing, it is green business. The most widely recognized application for aluminum is the beverage can. The aluminum can is the most recycled beverage container in America. In an average can, 68% is recycled content, the highest amount for any beverage container. In 2010, 58% of aluminum cans were recycled in the United States. This bill, to improve our understanding of municipal recycling, is vital for our industry to bring consumer recycling in line with aluminum recycling in other sectors, which is greater than 90%. It will also be vital to help our understanding of how we might raise our can recycling rate to the level of other countries, many of which are in the area of 90% or higher. Our industry has established a goal of reaching a 75% aluminum can recycling rate by 2015. We are engaged in various initiatives, including establishing and funding a new organization called the Curbside Value Partnership with other materials manufacturers. CVP works with municipalities to increase consumer participation in existing recycling programs. Our evaluation of the program indicates that it routinely results in a 17% increase in household participation, translating into a 22% increase in tons of recycled material. Data generation and analysis is a key requirement for cities implementing this program and is a key to the program's success. A robust material tracking and data gathering system is necessary because of the complexities of materials recycling value chains. For example, differences in material weights and scrap value complicate consumer behavior choices. Aluminum's material characteristics of high strength to weight and corrosion resistance allow for uses that weigh less than other materials performing the same job. Then measuring recycling by commingle weight alone undercuts the full benefit of aluminum recycling to the environment and its subsidizing role in many curbside programs. This is just one of many considerations which improved municipal waste data could influence. The aluminum industry is committed to increasing recycling because it is good business and good for the environment, and recycling efficiency should be a key consideration in our country's energy strategy. For these reasons, the aluminum industry is ready to work with EPA to improve our understanding of the waste and recycling streams. There are many proposed solutions to increasing recycling in America, but industry and policy makers first need the best data possible to understand which method is best. I look forward to answering questions. I would thank the committee again and the chairman, and thank you.
Thank you. And now I'd like to have Ms. Lynn Bragg. Thank you again for appearing, and you're recognized for 5 minutes.
Thank you, Chairman Shimkus, Ranking Member Green, members of the subcommittee. I'm Lynn Bragg, President of the Glass Packaging Institute, representing the North American glass container manufacturing industry. Thank you again for inviting me. After hearing EPA testify, some of you may be wondering why this bill is needed. Explaining how we make glass containers, I think, will help answer that need. Glass is originally made from sand, soda ash, and limestone. The raw materials are melted together at extremely high temperatures in a glass furnace, creating molten glass that's formed into beer, wine, and food and beverage containers. New glass containers also can be made from recycled glass or cullet. When we make new containers by adding cullet, we can operate our furnaces at a much lower temperature, reducing our energy use and emissions. In terms of production, approximately 25 billion glass containers were made in the United States in 2010. Our member companies can make over 3 million beer bottles a day at a single plant. At each of the 48 glass container plants in 22 states, recycled glass energy savings keeps our plants competitive against increasing global competition, helps the plants comply with Clean Air Act regulations, and keeps 18,000 people employed in high-paying salaried and hourly jobs. GPI member companies use cullet on a daily basis and compete heavily to buy it. Understanding the data behind the recycled glass we purchase and from which recycling system it comes from is a critical need for our industry. We know the majority of Americans are committed to recycling. As manufacturers, we rely on their voluntary efforts. There's a good chance that you recycle using the green or the blue bin. Have you ever wondered where the recyclables end up? We believe most people do, and the same is true for the manufacturing industries that purchase these recyclables. Currently, EPA issues a report on municipal solid waste generation, recovery, and disposal. In that report, EPA estimates the total amount of recyclables entering the municipal waste stream and the total amount recovered. However, EPA defines recovery as materials removed from the waste stream for the purpose of recycling. For glass, EPA also counts as recovery uses such as roadbed construction. Just collecting materials or using materials as roadbed is very different from the actual recycling of glass into new containers and other products such as fiberglass. Based on EPA's current reports, we have a rough idea of how many glass containers are collected. Glass plants know how much recycled glass they buy. We know that there is a big difference between those numbers. And right now, what happens between collection and actual recovery by a manufacturer is a black box. We don't know what happens to the material that gets lost along the way. We suspect that much of it becomes what the recycling industry calls residue, material lost to manufacturers after spending time and money collecting and sorting that material. Again, why are we talking to Congress about this issue? Isn't recycling a state and local issue? We emphatically agree that it is, but we also believe the federal government has a role in collecting and disseminating data. For example, the Commerce Department through the U.S. Census reports vital data on the production and sale of goods. That doesn't mean it regulates those activities. We think that EPA can play an important role in recycling by collecting information and making it available to everyone. With new data points on recycling that consider manufacturing end markets, state and local governments can evaluate different options for recycling. Municipalities may want to tailor their recycling contracts to reach different outcomes, and industry may find opportunities to form partnerships to recover more recyclable materials collected. Manufacturers frequently meet with states, local governments, the solid waste industry, brand owners, and environmental groups, and the need for better recycling data is frequently discussed. In fact, I'm attending such a meeting today. We all share the goal of increasing recycling, but the first ask typically involves information. What do we know, what we don't know? While the discussion draft doesn't allow EPA to force organizations to respond to information requests, we think EPA will get a better response than if industry were asking the questions. We know EPA will not get perfect information, but it will be an improvement. Right now, EPA issues their MSW report without an approved information collection request under the Paperwork Reduction Act. That means by law, EPA can only ask 9 people for information. This draft does not waive the Paperwork Reduction Act, but by requiring EPA to collect better data on recycling, EPA can go to OMB and get approval for an ICR, be able to ask more than 9 people for information, and produce a report that will help all of us better understand our municipal recycling programs. I'd also note that the draft is only intended to address the MSW recycling stream and not the industrial pre-scrap. Thank you. I'd be happy to answer any questions.
Thank you very much. Now I recognize Mr. Jonathan Gold. Sir, you're recognized for 5 minutes.
Thank you, Chairman Shimkus, Ranking Member Green, and members of the committee. My name is Jonathan Gold. I'm the Senior Vice President of the Recovery and Recycling Division of the Newark Group. The Newark Group is one of the oldest 100% recycled paperboard companies in the United States. This year we are celebrating our 100th anniversary. In 1916, my grandfather started the North Shore Recycled Fibers Paper Recovery Plant in Salem, Massachusetts. But I swear I haven't been with the company that long, only about 35 years, but paper recycling is in my blood. I want to thank the committee for the opportunity to present the views of the Paper Recycling Coalition on the importance of data collection for recovered materials. The PRC is comprised of 10 companies who manufacture 100% recycled paperboard and containerboard, basically cereal boxes, cake boxes, game boards, construction tubes, corrugated boxes, and beverage containers. PRC member companies operate over 400 facilities in 42 states, employing over 50,000 American workers in well-paying jobs. Recycling reduces the need for new landfills, saves energy, creates jobs, reduces greenhouse gas emissions, conserves natural resources, and supplies valuable raw materials to the American industry. It is the last point that brings me here today. Despite the well-noted growth of the electronic media, the demand for recycled paper products is increasing every year. Our society continues to be paper-intensive for numerous reasons, including a rising demand for packaging. Recovered paper is the only raw material that can be used by the 100% recycled paper industry, and by doing so, we are extending the fiber supply. Our raw material comes from homes, offices, and businesses all across this country. Each state is responsible under the Resource Conservation and Recovery Act, known as RCRA, for municipal solid waste, MSW. Programs and the systems for collection vary widely from state to state and from municipality to municipality, producing vastly different results. For more than 20 years, EPA has been generating an annual report on the characterization of municipal solid waste. It currently details how much MSW is collected and how much is diverted. However, that report has never been able to disclose how much of that diverted material is actually reaching the manufacturers who can turn it into a new product, and how much all of these recycling efforts are benefiting our society. Let me give you an example from my own personal experience. In the state of Massachusetts, which reports a 39% municipality recycling rate, the material that comes into our mill has a contamination level as high as 15 to 18% because of broken glass, plastic bottles, plastic bags, and steel cans, for example, as well as other unmentionables. When you factor in wet weather, this level can be as high as 22% on a day-to-day situation. To a large extent, this is caused by single-stream collection, a curbside collection process that allows for all material to be collected in one bin versus separating paper from all other collected material. This material is still counted by the Commonwealth as recycled. What is too contaminated for us to recycle in our mills ends up at the landfill, casting serious questions on the true recycling rate. Improved data would help us get a better handle on the problem in order to identify these solutions. We know that there is a great deal more that can be done to improve basic collection. For example, every 2 weeks we could fill Fenway Park in Boston to the top with paper that is not recovered for recycling. That's raw material and jobs that we will never see due to the inefficiencies in the collection system. The paper industry has done an astonishing job of increasing the recycling rate for paper, 81% over the past 20 years, so that now we are collecting 66.8% of all the paper available for recycling. However, with an ever-increasing domestic and international demand, we need better data tools to identify the paper that we are not currently assessing in order to stimulate U.S. job growth. The data collection bill under consideration today would focus EPA's attention on the material that is actually recovered for reuse in manufacturing. This material is the bulwark of our business and essential to maintain our position as a vital and vibrant American industry. In the current economic climate, municipalities are struggling to maintain funding for material collection. We understand their problems, and this proposal will not add to their burden. We want to be part of the solution to that problem, but we need better data in order to target our approach to increasing collection. We support this basic principle of this bill, but remain adamantly opposed to any government mandates on the private sector because they distort market outcomes and efficiencies. Mr. Chairman, this concludes my oral testimony. I would ask that the committee consider my written testimony on this matter on behalf of the Paper Recycling Coalition. I would be happy to answer any questions from members of this committee. Thank you.
Thank you very much. Chair now recognizes Mr. John Skinner from the Solid Waste Association of North America. Sir, 5 minutes.
Thank you. Good morning, Mr. Chairman, members of the committee. It's a pleasure for me to be testifying here about the importance of recycling of solid waste. It's a strategy that has significant environmental, energy efficiency, and economic benefits. We strongly support recycling, and we reviewed the draft discussion legislation and have some comments that we'd like to make about it. Let me just tell you a little bit about who I represent. Our members, 8,000 of them, are the people that collect, process, recycle, and dispose of municipal solid waste across the country. They are the professionals that are on the front line carrying out those programs. 35% of them work for the private sector, 65% of them work for the public sector, and we have 35 chapters in North America, 45 chapters in North America. Our mission is professional development of our members, education, training, scholarships, networking, certification, and publications. We provide our members with the tools necessary to do their jobs the best way throughout the year. Recycling is very important to our members. It's environmentally and economically sound, and we've provided an extensive array of programs for our members in the areas of recycling. I've listed some of those programs in my testimony, and in the interest of time, I'm not going to go over them, but it's a wide range of training, education, certification, research, and publication programs. Turning now to the draft legislation, we certainly agree that the manufacturing sector can increase its competitiveness, it can reduce its energy costs, reduce its emission levels, and improve the amount of materials that are diverted from landfills through the increased use of recycled materials. That's a goal that we entirely support, and we acknowledge that increasing energy efficiency in the manufacturing sector can increase employment, including higher paying jobs. And we acknowledge also that recyclable materials are perfectly acceptable feedstocks to produce new materials and products. It's important that the data specified in the bill lead to increased recycling, lead to increased use of recycling. And communities have many variables that they consider, but the key determinants of whether they recycle a material or ship it for recycling are cost and revenues. It's an economic decision, and I'm sure you all know the situation that local governments are in these days with respect to their tax revenues and their economics. We agree that improved data is very important, and more informed decision-making by policymakers will help private sector users of recyclables increase their understanding of what recyclable materials might be available. We also agree that the report called for under Section 4 of the draft bill would provide very detailed and very useful information at a level of detail which is not available now, and we think that that's an extremely good goal. We had 3 areas of concerns that we raised: the time frame for collecting this data, the cost estimate for collecting it, and the authorities that would be necessary to obtain that data. We've seen the changes that have been made in the current draft of the bill, and we think they go a long way in that direction. The 2-year time frame is much better than the earlier time frame that was indicated, and the fact that the authorization would be an annual authorization and not a 1-year authorization, annual over 3 years, would also be a very important direction to move in. I also heard Administrator Stanislaus say that he thought that $800,000 a year and longer than 2 years was necessary, and I think that we should listen to his reasons for that. There might be some very good reasons for that. Tracking the flow of materials throughout the economy, from collector to broker to manufacturer, could be a difficult task and could take considerable resources. Finally, whether this type of information can be obtained from voluntary information requests and existing published data is questionable to obtain it at this level. I'm not saying we shouldn't try, but we may come up short and not get the type of information that we need, and we might need to go back and look at other options. And we recommend that the committee consider ways of obtaining that information and increasing voluntary information submittals. And we do recognize the fact that this bill would provide EPA with the authority to conduct more wide-scale surveys, would give them the ability to go and get approval of those surveys under the Paperwork Reduction Act. But the question here is how to increase the response rates. So let me say we would be pleased, my association would be very pleased to work with EPA on this effort, and we would encourage our members to cooperate with it. We believe the information would be very useful and helpful to both the suppliers and the users. Thank you, Mr. Chairman. I'd be happy to answer any questions.
Thank you, Mr. Skinner. Now I'll recognize myself for the first 5 minutes, and I'll start with, just a basic observation. Recycling is good for everybody. There's really no downside. So the question stems from, in the new Congress, the new House specifically, we shy away from, or we're trying to shy away from federal mandates, mandating things. And so, so part of this bill, my understanding is, obviously getting the EPA to collect information about a voluntary system. So a question is, do you think the discussion draft, when introduced, should mandate federal recycling systems, or recycling goals? Mr. Johnson, briefly if you can.
No. We believe actually that those solutions do exist. There are many of them. And this bill does exactly what it should, which is to collect more information and reevaluate the way we analyze that data so that we can make those decisions after that fact.
Great. Ms. Bragg?
I agree with Mr. Johnson. The discussion draft and future legislation should not prescribe or mandate recycling programs at the federal level. Shouldn't be mandating any.
Mr. Gold, you sounded a little impassioned about this in your opening statement. You concur?
Well, absolutely not. It's not practical or economical.
Okay, great. Mr. Skinner?
Certainly not at this stage. There's a lot of things that can be done to increase recycling short of going that far.
Do you support any federal mandates or regulation as a way of increasing recycling?
Not at this time. We don't have enough information to know what those programs would look like and how they would affect our industry and our material stream.
Ms. Bragg?
No.
Mr. Gold?
No.
Mr. Skinner?
Not regulations or legislation, but I think the federal government can play a very significant leadership role in encouraging people to do these types of activities.
And let me just follow up on that, because it obviously in the opening statement it seems like everybody's pretty supportive. I think, Mr. Skinner, you were raising some concerns, but not stop, no way. This is, and as I mentioned earlier, I'm co-chair of the Recycling Caucus. One of the reasons why was to make sure that on the corporate side, people really understood how much is recycled there, and it's really a municipal solid waste issue. Good data could help us answer one question that perplexes me: single source versus multiple bins. And Mr. Gold, you raised the contaminated or tainted material in a single source issue. But in reality is, we don't know nationally how much is lost. There's no way we can provide information to local communities or you all to say single source is good because more people, my observation, more people find it easier to put everything in a single bin. Simplicity helps. So there may be more generated recyclable material, but then we forget about that portion that might be tainted and thrown out. But we don't know that answer. Is that correct?
That's absolutely correct. That's one of the problems that we have pointed out repeatedly when we cite the need for a study of this type. We need to know more about what's happening to the material between collection and reclamation.
Ms. Bragg?
That is absolutely correct. Mr. Johnson's answer is perfect, really. We have the same issue.
And you're with the glass recyclers, is
Yes.
that right? So I toured the waste to energy plant across the river, which is another huge option. They're very successful in even reclaiming some of the metals, but glass, I think, melts. And that's one thing that if it's a single source, goes to waste energy. I don't think the glass portion is recoverable. Do you know anything about the waste and energy, and would you lose all that?
Not so. I'd have to do some additional searches on waste to energy in terms of glass. But just in terms of recycling, if the glass isn't collected properly, it does break into very many small pieces and usually gets entangled with paper and other liquids and becomes a big mess.
Is colored glass a challenge anymore for your sector? Or?
No.
No. Okay. Mr. Gold?
Nationally, no, but internally with our own company, we know it's 10 to 15 to 18% contaminants from single stream. It's unscrambling a scrambled egg.
Right. Yeah. Mr. Skinner?
Yeah, the important thing is to understand why municipalities go for single stream or single sort. It's an economic decision. It makes collection of the material much less costly. And collection is 80% of your costs of managing of wastes. If you have to send down multiple trucks to pick up multiple streams, or you have sorting by the collection is much more expensive. You can put it all in one container. It reduces the collection cost if you can collect it automated. So that's the reason that they're moving in that direction. But I do acknowledge that when you do that, you have to be very, very careful about your materials recovery facility and sort out the contaminants so that the products that you're producing are valuable.
And I'll end on that, but I guess my final point is, I think centralized voluntarily information is better than no information. To start making these decisions, either from the municipal waste collection side or the folks who want to be end users of recycled products, there is a gap there of things we don't know. And so I'm very interested in this process, and we'll follow it forward with great consultation with my friend, Mr. Green. So who I'd like to recognize for 5 minutes for questions.
Thank you, Mr. Chairman. Again, thank our panel for being here. This question is for anyone on the panel, and many states and communities already issue reports on the outcomes of their recycling initiatives. Is there a reason this type of survey could not be attached to those current reporting regimens?
Are we still going in order? The first reason is scope and scale. Many of municipalities attack their questions about their municipal material streams at the local level and answer those questions. Industries need information about the national and international movement of our materials and the material flow.
Okay. Anybody else? Is that pretty well everyone's agreed? What makes you think that voluntary responses to the EPA would differ from an initiative that your associations could jointly initiate? I know, for example, I represent 5 refiners, and they cooperate all the time on surveys. It's pretty regular. Would there be any different than what your associations would cooperate on?
Speaking for the glass industry, we do have our own internal surveys, but the type of information that we're looking for in terms of this gap is something that we couldn't do alone in terms of our own industry, because we are really looking for additional information where we can get a better handle on the end markets. And we also need to know, the gap in the middle, what's happening to it. And that's very difficult for us. We wouldn't be able to handle that on our own.
But a good example, Mr. Skinner represents the group of recyclers. And when somebody brings in, they bring in glass, they bring in paper, and in the case of the city of Houston, where I live, they bring in e-waste that, you know, you have to separate from everything else. It seemed like that the cooperation, you could get a lot of this good information, you know, with your associations doing it, with the folks who actually are picking up and are taking the receiver of that, those recyclable items.
You are making a very good point, but many of us are involved in groups that are seeking answers to why we aren't getting more recycled material back. We are working cooperatively together, but we really do feel that if the government, if EPA could request this information, this additional information that we're asking for, we'd have a better overall picture than trying to piece it all together ourselves.
Okay. Mr. Skinner, you represent a huge number of groups, I assume municipalities, but also private recyclers. Like in my area, in unincorporated Houston, Waste Management has a recycling program that the community may decide, because it typically increases their cost to do that. So you represent both private and public entities.
That's correct.
When your members pick up that waste, I assume they divide it up, or do they just have the different associations that specialize in it? You know, does a glass person come in and get your glass, or aluminum person come in or paper?
It generally goes to a facility after it's collected, and depending upon how it's collected, it may need to be sorted further and sorted considerably if it's collected as commingled. And then it's basically baled and goes to a broker, and the broker would take it to the ultimate end markets. So there's a process where they work through the existing scrap markets to get that material. In response to your prior question, I think there is good data from the trade associations on how much material is being used and how it's being used within their manufacturing. The data that's limited is the supply side. what is coming out of the municipalities and how much more could come out of municipalities. That data is available. Some of it's on websites, and a good data collection effort could get it and bring it all together. You might not get a complete national picture, but I think working on the supply side is important.
Okay. Let me ask, in the last 30 seconds, I have a real interest in e-waste, and I've partnered with the City of Houston on a number of these e-waste events. And Mr. Johnson, you talked about the end user, because I know a lot of my scrap paper is actually sent overseas. I don't worry about how they dispose of scrap paper as much as I am how they're doing, and it's been very publicly internationally, how some countries take e-waste and literally it's a danger to the folks that do it. I want to be able to track that, and I know that's not today's hearing, but Mr. Chairman, somewhere along the way I'd like to see how we track what e-waste is picked up now and how it's tracked to where we know what's being done with it. And I appreciate the time.
Gentleman's time expired. I recognize gentleman from Colorado, Mr. Gardner, for 5 minutes.
Thank you again, Mr. Chairman, and I know my colleague and I, Mr. Latta from Ohio, have a number of issues in common in terms of concerns when it comes to recycling and the facilities that we have in our districts, bottle manufacturing and glass manufacturing, glass packaging. And so, Ms. Bragg, direct a couple of questions your way. In your testimony, you claim that better recycling will help energy-intensive manufacturers reduce their energy costs and greenhouse gas emissions. How does the bill that we're discussing today fit with that goal? How does it relate to international competition and job preservation right here in the United States?
Thank you for the question. When a glass manufacturer uses cullet instead of raw materials to make glass, we can operate our furnaces at lower temperatures. So once the cullet has already been melted into glass, it's much easier to melt it again. And lower temperatures mean less energy use. The glass industry relies mostly on natural gas to run our furnaces, and less energy use means lower emissions, and they are, of course, directly related. All of this helps us compete internationally and keep jobs here in the U.S. As you would expect, profit margins are slim, and glass companies compete for customers by lowering their prices. But you can't set your prices so low that the company stops making money, and then if that happens, you have to close your doors and people lose their jobs. And unfortunately, some of our members have lost customers to foreign glass plants, which really don't operate under the same regulatory environment that we have here in the U.S. So we need to do everything we can to be cost effectively keep our energy costs and air emissions down. And really using cullet instead of those raw materials to make glass really helps us achieve those goals.
And one thing I didn't realize until visiting the manufacturing facility is the importation of recycled glass into the country. Is that still occurring regularly? Within the country, excuse me, like from, taking recycled glass from California to Colorado to meet needs at the plant there.
Yes, absolutely. Glass. Cullet is transported from unbelievable locations to be used in a glass manufacturing plant thousands of miles away.
And the EPA believes that the bill requires that it sample every single community and recycling facility in the United States. Do you agree with that assessment?
No, we do not. I mean, even right now, the EPA uses statistical sampling and extrapolation of data, and we don't believe they'd have to go to every single municipality across the United States.
Thanks. And you mentioned that the information collection request in your testimony. What is that, and why does that matter?
Well, as I mentioned in my testimony, the information collection request is under the Paperwork Reduction Act, and it limits the amount of people you can ask for that information. So again, with just 9 people, the reports are estimates that are really extrapolated from a few surveys. And it's my understanding that the EPA has not even tried to get an information collection request to request any recycling data like the data we're asking for in the discussion draft. So again, like the discussion draft doesn't waive the Paperwork Reduction Act, but it does require EPA to collect information in accordance with an ICR. So they would then have to put together the surveys, seek public comments, submit the surveys to OMB, and given the legislation, we would expect OMB to approve the surveys. So they'd be able to ask more people than just 9.
Thank you, Ms. Bragg, and I yield back my time.
Would the gentleman yield for his last 50
Yes,
seconds?
absolutely.
We're a market-based competitive majority in the House right now, and why wouldn't just the purchasers of recycled goods send a price signal? There will be a break point where adding the recyclable material to your production process is profitable based upon EP regs, energy costs, and like, and when it's not. I'll have to answer this question for my colleagues, why wouldn't a price signaled by you all on the cost of a input product, the recyclable, send the signal, we want more recycled cans, we want more recycled glass, we want more recycled paper. Why isn't that working?
I would make 2 points. First is because that signal is not received by the disparate end users of the products who are the first step in recycling the material. So the average household is not recycling aluminum cans because they can get back the individual monetary value of each of those cans. They're doing it because it's the right thing to do for the environment and because it's an available service in their community. The second point I would make is that those price signals are being sent through our economy. Our members in the United States each year, the aluminum that's produced in the United States is almost half recycled material. And we have a shortage still of of material coming into our processes. So we are sending that signal. But the first and possibly the second step of the scrap stream is never going to receive that signal.
Ms. Bragg? Same.
I can't really speak directly to price. Our industry is especially very wary of antitrust. We really abide very strictly by the antitrust regulations. So individual companies could respond to that. I know as individual companies, they work every day with recyclers and processors.
I think in the paper side, the 2 major grades that are recovered are corrugated and residential mixed papers, and we're way over 70, well, almost 80% recovery rate on those 2. There's not a lot more that can be recovered unless you go into the landfills and start to pull back.
Mr. Skinner?
If the price signal is strong enough, and if there are contracts for the long term, municipalities will put in the collection programs to get that material out. And that's what needs to be done. It has to be a program that you can't turn on and off, municipal recycling. It has to be something that you sustain over a period of time.
Great. Well, we appreciate your testimony, and thank you for your time. And with that, we'll impanel the 4th panel. Thank you.
We can't move it in Massachusetts. I got it. We don't. We just can't. Well, the bottle, but we don't get it.
We welcome the 3rd panel, and I'll do as I did, the 4th panel, and I'll do as I did to the 3rd panel, introduce you all at one time, and then ask you to give your opening statements. So with us is Ms. Susan Heidelbrand, professional engineer, Chief Engineer, Texas Commission on Environmental Quality. We want to welcome you. Mr. Walter Bradley, Director of Government and Industry Relations with the Dairy Farmers of America, and having the largest dairy county in the state of Illinois. I particularly welcome you.
Great.
It's not huge, but it is the largest.
We'll compare.
Mr. Ed Hopkins, Director, Environmental Quality Programs with the Sierra Club. Sir, welcome back. And with that, your full statements are in the record. As always, you have 5 minutes, and we'd like to start with you, Ms. Hildebrand.
Good afternoon. Again, my name is Susanna Hildebrand, and I'm the Chief Engineer at the Texas Commission on Environmental Quality. Thank you for the opportunity to speak today. The Texas Commission on Environmental Quality regularly weighs matters that affect the environment and economy. Decisions made by TCEQ are based on the law, common sense, good science, and fiscal responsibility. The Superfund Common Sense Act, H.R. 2997, is also based on these principles. This hearing is not about whether manure should be regulated. Animal agricultural operations that produce manure are already adequately regulated under other environmental laws, such as the Federal Clean Water Act and the Clean Air Act, as well as state-specific authorities in Texas, the Texas Water Code, and the Texas Clean Air Act. The question is whether additional regulatory burdens of CERCLA are necessary for manure. H.R. 2997 would remove the question from the purview of the courts and EPA, ensuring that resources dedicated to CERCLA are used to address the problems that Congress had intended. The Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, as amended by the Superfund Amendments and Reauthorization Act, SARA, authorizes federal cleanup of releases of hazardous substances, imposes liability for cleanup, and provides restoration or replacement of natural resources affected by a release. CERCLA defines a hazardous substance as a substance designated under various acts, including the Clean Air Act and the Clean Water Act. CERCLA also specifies reporting requirements when specific quantities of hazardous substances are released into the environment. CERCLA Section 103A excludes federally permitted releases, including discharges addressed through a National Pollutant Discharge Elimination System and PDS permit from the release notification requirements of CERCLA. This exclusion is appropriate because effective regulatory and environmental and enforcement mechanisms already exist under the applicable laws, including the Clean Water Act and the Clean Air Act. Specific agricultural operations, such as the confined animal feeding operations, CAFOs, are already regulated under the NPDES program and the Texas Pollutant Discharge Elimination System, TPDS program in Texas. TPDS permits regulate discharges from CAFOs. They include best management practices requirements for manure management. With regard to air emissions, facilities in Texas are subject to the Texas Health and Safety Code through the Texas Clean Air Act and must be authorized prior to construction. In considering issuance of a permit, the TCEQ considers possible nuisance odors and addressing handling and storage of manure. Violations of state law or agency regulations, including odor and nuisance conditions, are subject to enforcement. Congress should make it clear that the current environmental laws are adequate and that regulation under CERCLA is not necessary. Moreover, as the United States EPA describes in its Superfund website, the CERCLA law was enacted following the discovery of high-risk toxic waste dumps such as Love Canal in New York and Times Beach in Missouri in the 1970s. Also, according to EPA, this law created a tax on the chemical and petroleum industries and provided broad federal authorities to respond directly to releases or threatened releases of hazardous substances that may endanger public health or the environment. CERCLA was never intended to address the removal or cleanup of agricultural sites that comprised manure created by biological processes, as defined by H.R. 2997. The CERCLA and Federal Superfund program have had tremendous benefit in cleaning up legacy pollutants from some of the nation's worst toxic waste sites. Applying CERCLA to agricultural operations that produce manure is not consistent with its original intent and will likely result in the diversion of federal, state, and local resources away from the cleanup of sites that contain hazardous substances and truly present the most significant risk to human health and the environment. Manure clearly does not fit into this category. Regulating manure as a hazardous substance would be unduly burdensome to business owners who, by and large, manage manure properly. Congress should make it clear that manure is not a hazardous substance regulated under CERCLA. If Congress does not act to exclude manure, then it will allow the courts or EPA to define CERCLA applicability, resulting in ambiguous, duplicative, and inappropriate requirements to other mechanisms already available to state regulators charged with the mission of protecting human health and the environment. There's no additional benefit to regulating manure under CERCLA, as there are regulatory programs already in place to address environmental concerns. The facts are clear. Stringent requirements meant for truly hazardous substances, such as those imposed under CERCLA, should not apply to manure.
Thank you very much. Now I'd like to recognize Mr. Bradley for 5 minutes.
Thank you, Mr. Chairman, members of the committee. I'm former New Mexico Lieutenant Governor Walter Bradley, and today I am here to represent the 15,000 farmer owners of Dairy Farmers of America. And we are in strong support of H.R. 2997. This measure will once and for all affirm that the very same livestock manure that is used to fertilize our nation's organic crops is not a hazardous or toxic substance under Superfund. The last few years have posed extraordinary challenges for producers across the country, but especially in my region, where a majority of feed is imported from other regions, and in 2009 and 2010, our producers dealt with a very volatile milk price and input costs, a supply-demand imbalance, and other world factors which drove down the price of milk and our operating margins. Many lost a generation's worth of equity while others left the business. In New Mexico, most every one of our survivors had to take on more debt. Prices, feed costs, supply-demand fluctuations, and weather are all things farmers cannot always control. The uncertainty that these and other factors bring to the industry is startling. But one thing we can deliver, that we should be delivering to our dairymen, is regulatory surety. I ask this committee to do just that. Specifically, make clear the intent of Congress to not regulate manure under CERCLA and EPCRA. We are not seeking an exemption from the Federal Clean Water Act or the Clean Air Act or similar state laws, including any federal or state worker protection laws. We're merely seeking clarification under CERCLA and EPCRA that animal manure does not necessitate an emergency response, nor does it create a Superfund site. It should also be pointed out that both CERCLA and EPCRA include exemptions for animal operations. The example of the definition of hazardous chemical under CERCLA excludes any substance to the extent it is used in agriculture operations. Without this clarity, the courts can and ultimately will be left to redefine the regulation, and some lawyers have already jumped on this bandwagon. In fact, in 2009, the Middleton law firm in Georgia and the Spear law firm in Missouri formed the Center to Close and Expose Animal Factories and have filed numerous lawsuits around the country on all sizes of farms. I don't believe Congress ever intended for manure to be regulated as a hazardous substance, and in recent history demonstrates that Congress understands the value of manure to America and has encouraged its creative use. Laws have been passed and initiatives undertaken to encourage rural America to participate in the renewable energy field through the development of on-farm energy production by producing biogas, electricity, and biodiesel derived from manure. This very Congress has acknowledged manure's value by funding research, passing tax credits, and mandates for its use. How can we possibly ask dairy producers to invest millions of dollars in technologies to support the nation's energy needs without addressing the threat that manure will be classified as a hazardous substance? And how are organic farmers going to fertilize their crops? Government regulations forbid the use of manufactured fertilizers. Besides being used for bioenergy production, manure is frequently spread on fields for fertilizer. This simple, long-standing, and environmentally respectful practice is threatened by the insecurity surrounding manure's possible regulation under CERCLA. Conversely, I find it interesting that petroleum-based fertilizers, the alternative to the naturally occurring fertilizer, are exempt from these laws. In closing, I'd like to point out that animal agriculture operations are subject to a vast array of federal, state, and local environmental laws and authority to deal with every conceivable environmental problem presented by them. They include the Clean Air Act, the Clean Water Act, the Resource Conservation Recovery Act, the Toxic Substance Control Act, FIFRA, soil conservation, dust and odor mitigation controls, as well as nuisance laws, which have all been applied broadly throughout the country to provide environmental protection from every conceivable aspect of animal agriculture operations. In New Mexico, we have the Groundwater Protection Bureau, the Surface Water Bureau, the Air Quality Bureau, and a set of New Mexico dairy rules for permitting of all dairies, in addition to all the federal rules and regulations I mentioned above. There has been no indication that environmental laws such as these are inadequate, and we certainly don't need another layer of duplicative regulatory actions. I hope Congress addresses this issue and makes clear their original intent that manure from animal agriculture is exempt as a CERCLA hazardous substance, and I commend Congressman Long for his leadership on this issue and hope to soon see H.R. 2997 passed and signed into law. Thank you, Mr. Chairman, members of the committee, for this opportunity.
Thank you very much. And our final witness for today and the fourth panel is Mr. Ed Hopkins, Director of Environmental Quality Program, Sierra Club. Sir, welcome.
Thank you, Mr. Chairman. Ranking Member Green, appreciate being here today representing the Sierra Club. We have worked at the local, state, and federal level for over the past decade to protect public health and the environment from factory farm pollution. Unlike in earlier decades, many of today's large-scale operations contains thousands and in some cases even millions of animals in closed buildings, producing huge volumes of waste material that compose serious threats to air and water. A recent GAO report cited an example of one hog operation generating some 1.6 million tons of manure a year. That's about 1.5 times the amount of sanitary waste produced by the city of Philadelphia. There's an important difference, is that the city of Philadelphia has a wastewater treatment system. The hog operation doesn't. Some large livestock operations now find themselves producing more waste than they can responsibly manage by traditional land application practices. But instead of adopting more advanced treatment or moving waste materials outside of watersheds that can't tolerate more pollution, some operations simply dump excess manure. Whether they allow leaks and spills from manure storage lagoons, spray or apply manure to frozen or bare ground, or simply over-apply far in excess of the agronomic needs of crops, their practices result in pollution of ground and surface waters with excess nutrients and dangerous pathogens, arsenic, other toxic metal compounds, and antibiotics. As a result, more than half of the states cite animal feeding operations as sources of water pollution. Some of these operations release more ammonia into the air than industrial facilities. The GAO documented many government-sponsored or peer-reviewed studies that directly or indirectly linked pollutants from animal feeding operations to specific health and community environmental impacts. That's why cities like Tulsa, Oklahoma, and Waco, Texas, desperate to protect their drinking water from upstream manure pollution, resorted to CERCLA as their only source of relief. These cities want to protect their ratepayers from footing the bill to clean up somebody else's pollution. In Waco, for example, the city had to spend some $54 million to install new drinking water treatment systems. Passing H.R. 2997 and exempting poultry and livestock waste from CERCLA and EPCRA will only exacerbate these real-world problems. It will increase threats to drinking water supplies, force water users to bear the cost imposed by sloppy operators, and withhold important information about air toxics from emergency responders in neighboring communities. What is the problem that proponents of this bill are trying to solve? Are they trying to stop lawsuits threatening farmers? There have been 3 lawsuits to address manure-related contamination of water in CERCLA's 32-year history. Isn't it completely understandable that communities want polluters held responsible for contaminating their drinking water? Is it overregulation of agriculture? If anything, poultry and livestock operations are grossly underregulated. 29 states report that CAFOs are responsible for pollution. Only 40% of 20,000 large livestock and poultry operations have obtained Clean Water Act permits. And as far as I'm aware, no livestock or poultry operation in the country has a federal Clean Air Act permit. Is it duplication between CERCLA and the Clean Water Act? Actually, these laws were carefully crafted to complement one another. If an operation has a Clean Water Act permit, the releases covered in that permit are shielded from CERCLA. CERCLA is the only federal law that allows for state and local governments to recover cleanup costs from those responsible for contaminating drinking water supplies. Are these laws making manure into a hazardous waste and turning farms into Superfund sites? No one is arguing that manure itself is hazardous, and no one is seeking to ban its use as a fertilizer. If a farm operator is using manure as a fertilizer, there is no liability under CERCLA. There's a specific exclusion for that in the law. Only farmers mismanaging manure so as to cause hazardous releases of phosphorus and other pollutants into water need be concerned. In the history of CERCLA, not one single farm has been named to Superfund's national priority list because of manure. This bill does nothing to help responsible farmers. It's aimed at eliminating legal safeguards communities can use to protect their drinking water supplies and their ratepayers from irresponsible livestock and poultry operators that are dumping their manure and causing pollution. Thank you, Mr. Chairman.
Thank you, Mr. Hopkins. Let me go first to you. Does the Clean Water Act, Section 311F, authorize recovery of costs incurred pursuant to hazardous substance mitigation requirements under Section 311C of the Clean Water Act?
Not to my knowledge, sir.
I think it does. And the question would be, does 2997 change those authorities?
The bill doesn't amend the Clean Water Act.
So if I am correct and the Clean Water Act does allow recovery, then this bill would not affect the recovery of those costs. I mean, if we're just following the basic debate. Obviously, we'll have to get you to look at whether the Clean Water Act authorizes recovery costs, which you don't know the answer to.
Yeah.
We think it does.
Yeah. My understanding, sir, is that the reason that the city of Waco and that Tulsa sued using CERCLA was because that was a statute that best provided them the possibility of getting
They also sued under the Clean Water Act, and that was settled out of court. So it was a settlement between the two parties, so it never went to full litigation. Let me ask, same question on the Solid Waste Disposal Act, authorized EPA to obtain information or inspect facilities where hazardous waste have been generated, stored, disposed of, or transported. Would H.R. 2997 change any of these authorities?
Well, manure is not a hazardous waste, so it wouldn't be covered by.
But this is under the Solid Waste Disposal Act.
Yes, but that is regulating hazardous waste. That's what the Solid Waste Disposal Act does. And manure
but if the solid waste, if the hazardous waste is a solid waste, then under Section 3007 of the Solid Waste Disposal Act, authorizes the EPA to obtain information and inspect facilities. So the question is, in the proposed bill, would that change that authority?
No, the proposed bill would not change any authority under that law.
And then Section 7002 of the Solid Waste Disposal Act authorizes citizen suits against any person of the federal government to enforce the solid and hazardous waste laws. Would H.R. 2997 change these authorities?
No, it doesn't.
Again, Section 7003 of the Solid Waste Disposal Act gives EPA authority to address imminent hazards and issues orders necessary to protect the environment. In fact, EPA has used this authority before in pursuing a livestock operation. Would H.R. 2997 change these authorities?
No, sir.
Section 112 of the Clean Air Act requires air emissions reporting on hazardous air pollutants. Does H.R. 2997 change these authorities?
No, it doesn't amend the Clean Air Act.
Thank you. Let me ask, Mr. Stanislaus, who testified for the EPA, kind of seemed all over the board. In one comment, the comment was manure is not hazardous waste, but then he went down and then flipped and said, well, the component parts of the manure is hazardous, and I found his testimony quite confusing to the point that I just decided to let him finish and move forward. Let me ask for, let me go back to Mr. Hopkins. Are you all a party of the suit to the EPA which caused the reevaluation of, and their filing under the Federal Register of October 21st, 2011? Mr. Mathis talked about suits filed. Was Sierra Club part of filing a suit in this case that helped encourage the EPA to relook at their position?
Mr. Chairman, I'm sorry I don't know the answer to that, but I'd be happy to provide that for the record.
That would be helpful. So, finally, Ms. Hildebrand and Mr. Bradley, you did hear the EPA. Mr. Mathis, in his testimony, I'll give you each 20, 25 seconds to respond to anything you heard that you think that we might want to raise our concerns.
Well, I'm not sure if Mr. Stanislaus is not as familiar with the Clean Air Act or the Clean Water Act, and that's why he answered as he did. But it seemed that he thought that there was nothing that could that the federal government could do to compel immediate action if there were a lagoon overflow or something to that effect. And my information indicates that the Federal Water Pollution Control Act, Section 504, is the piece that the EPA administrator could use to seek immediate action. And Section 303 of the Clean Air Act allows EPA to bring action for relief as well.
And it's your job as a commission member to ensure the environmental quality of the citizens of the state of Texas. Is that correct?
Certainly. That role is very important to our agency.
Thank you very much. And Mr. Bradley, just in response, and my time expired.
I agree with what was just stated, and I would also go, I was a little concerned about his wishy-washiness on phosphorus, et cetera, which is clearly, all science says that animal-procured phosphoruses and phosphates are not the hazardous waste that the chemically man-made produced are. They're totally different, and I think he got confused there, which kind of bothered me. But
well, I thank you for your time, and now I'd like to yield to the ranking member, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. And I think, you know, we're talking about the difference in size. You know, my average dairy farmer in Texas is really not that large compared to some other farms. And in fact, let me ask my question to Ms. Hildebrand. One, I appreciate you being here. And having served many years in the state legislature, I appreciate the diligence of our Texas Commission on Environmental Quality, or whatever we call it now. I know that's the current name. Has the state of Texas ever used either clean water or clean air actions against for example, you know, a huge facility, whether it be for dairy, large dairy facility, or even a stock, you know, where they stock? I know up around Amarillo and parts of Texas, we have huge stockyards that are really just factories for our beef. And we like it, but we also know, because the size of those facilities, it may not be, you know, a farmer who's running, or a rancher who's running, you know, a few cattle on their 100 acres, which is not the issue. In fact, they probably recycle theirs as compared to a larger operation. Has the state ever used a clean air, clean water action on those?
Well, I know of a couple of examples, and I can give those to you in a written response.
Okay, I appreciate that.
But in general, I would say that typically we have the authority under the Clean Air Act, both the Texas Clean Air Act under the federal, and if, for example, there was a nuisance condition that occurred as a result of a large facility, we would go out and investigate, because if a nuisance occurred as a result of something like that, we would expect there to be a permit issue. And so we would look for permit violations, either whether that's under the TPDS or under the Clean Air Act permit that they received.
Okay, what if they don't have a permit?
So those emissions that would come from the manure for air are authorized under permit by rule. So they may not have an explicit permit that they received from the state, but they are authorized. Or they are operating under air emission allowances that are provided for in the water permit. Okay.
Mr. Hopkins, I know there was a 2003 National Academy of Sciences report on pollution from animal feeding operations. The Academy found that multiple operations emitted multiple pollutants, including ammonia, hydrogen sulfide, particulate matter, and greenhouse gases. In 2011, EPA estimated 80% of the U.S. ammonia emissions were from agricultural operations. What are the potential health impacts from large-scale ammonia emissions?
Well, ammonia emissions can cause a host of respiratory problems, eye, ear, nose, and throat problems. It's also a precursor to fine particulate matter. Somewhere between 9 and 11% of the nation's fine particulate matter has its origin in ammonia. So that is a very serious health problem, as you know, and that can again, cause all kinds of respiratory and cardiovascular problems.
I only have a couple minutes left. We heard earlier today that other environmental laws, and just now that address the risks, and that the liability and reporting requirements under Superfund are redundant and unnecessary. Are there provisions under other environmental laws that will require cleanup of contamination from manure and ensure that responsible parties will pay for that cleanup?
I'll take a shot at that, okay. Congressman Green. In the state of New Mexico, part of an answer to your earlier question, the state of New Mexico took action on a spill into the Rio Grande River by a dairy. That dairy was sued. That dairy was ordered to clean up and to change their structure. They were in violation of their permit, so they paid a fine. They paid their money. And the state of New Mexico does have a Superfund that they've created for spills, because a lot of these people don't have any money. We take all we got, and then we go from there.
Okay. So it's actually, New Mexico has a state Superfund, I guess, for this, so it's not under.
But we also use the Clean Water Act, and which is in coordination with our surface water ground bureau.
Ms. Hildebrand, is that similar to what we have in Texas? You know, I'm under disadvantage. I have a very urban area, and believe me, I have refineries and chemical plants fence to fence, so I'm real familiar with that. But you know, my ag area is just a little bit different, so I'm learning.
Certainly, as I understand it, the Texas Health and Safety Code and the Texas water codes allow for us to pursue relief from those facilities if there were an environmental issue that was resulting from their action.
Including parties assigning responsibility to the party and making them pay.
I believe so.
Okay. Mr. Hopkins?
Well, I would say it's not just a question of whether state regulatory agencies have the authority to do that, but whether other parties like cities have the authority to do it. And I think that's an important facet that CERCLA provides that maybe these state laws don't.
Okay. The example, and I only have a few seconds left, I know Waco, and Waco had to sue. I assume they were suing under not only state law, but also city ordinances in Waco, Texas? Because I think in Houston, we would have, we have ordinances for public nuisances that could be applied maybe, unless they're exempted by state law.
I think that the majority of their, the crux of their lawsuit, and again, it was settled, so it never went right. The majority of their issue was violations associated with the Clean Water Act. Certainly, CERCLA entered into it, and there's a question about the phosphorus that I think Mr. Bradley talked about. But at the heart of the issue, I think it was a Clean Water Act question.
Okay. Ms. Hopkins, let me give you final, if you have any time. Well, I'm out of time, but just so you could respond, the current law is not available even to municipalities if they have an ordinance?
Yes, I think that the reason Waco used CERCLA was because they didn't want their ratepayers to foot the bill for the pollution that they were having to clean up.
Yeah. Well, and that's, obviously I know about my Superfund sites, and thank Texas Environmental Quality and EPA on Lightspeed to put a dioxin facility, and we're still working on that, by the way. It's encapsulation, I understand, is not working. But anyway, thank you, Mr. Chairman, for the time.
Yeah, the gentleman's quite welcome. And we'd like to thank the panel for being here and answering our questions. I think 1 minute, Mr. Bradley, and I think one thing to consider on CAFOs is the location. Most CAFOs are going to be in rural America. That addresses the ammonia kind of debate, and the ammonia concentration is a concern on air emittance. But when you've got a CAFO that it's in rural America, rural Illinois, and it's 20 miles from the nearest community, the ammonia issue and intensity is not. I mean, we think we still got Clean Water Act issues, compoundment issues. Those are still in the debate. We think those are kind of covered. But having said this, Mr. Bradley?
I just wanted to make a quick clarification, if I might, about the Waco, because I heard a lot about Waco in here today, and there's a lot of bad information floating around. I think a little more research ought to be done.
Well, if the gentleman would yield, we're going to ask for the final judgment to be filed as part of this record, because it addresses some of the questions that were raised, I think, especially on phosphorus, that you had raised, and the difference on that. So,
okay.
A brief.
Well, Mr. Chairman, I know I'm familiar also with the problem in rural areas, but what we're having in Houston is I had a lot of dairy farmers up in Tomball, Texas, and some good families, but because of the suburbanization of it, you know, the cities moved out there, and it's made some conflicts that folks, when they moved there, they didn't realize there was a dairy farm down the road. We have that same problem in other areas too, but so it can happen, particularly in the suburbs, of growing out to the rural.
Those city slickers coming out to rural America, they ought to make sure they know what they're buying.
We want all those rural.
So with we have 3 submissions we'd ask unanimous consent for. The first one is a letter from the National Association for Pet Container Resources. The other one will keep the record open for 10 days and make sure we are able to see the letter that you'd asked to be submitted, which is from the National Association of SARA Title III Program Officials. And then the last one, which I need just to be corrected on, it's a brief on the Waco case. So without objection.
Well, whose brief is it?
Well, we've already run it by the.
Okay. Have you? Okay. Mr. Chairman, let me just look at it and see.
Okay, we'll
having done briefs, if my client wanted me to do one, I'd do it.
Yeah, we'll do the same thing. As for the 10 days, you guys have a time to either accept or reject on that. And we appreciate your time and effort. And again, thank you for coming. And this hearing is adjourned.
Good job. Suzanne, good job. Excellent.